Yes. 79.
Lord, with 2 weeks time, we schedule the necessary documents, my lord.
Pardon? All right. When do you want?
2 weeks, my lord.
After 2 weeks, then it will go in March. Then it go in March. 2 weeks, all right. Then 21st February.
My lords, there's a mentioning, my lord.
Lord, one matter for admission tomorrow, urgency is this, my lord. Election for the post of Adhyaksha of Gram Panchayat is scheduled the day after tomorrow. And in fact, my lord.
What is scheduled?
Please, my lord.
What is scheduled tomorrow?
Election for the day after tomorrow, election for the post of Adhyaksha of Gram Panchayat. Before the expiry of 15 months, my lord, they have issued election notice, my lord. In fact, no confidence motion and moved it. In fact, as per section 49 of the act, before the expiry of the 15 months, my lord, they are not supposed to do. Day after tomorrow it is scheduled. That's why, my lord, matter is urgency. May be taken up tomorrow, my lord.
All right. Subject to removal of office.
Tomorrow. Please.
My lords, this is a contempt proceeding measures. In the writ petition, an order was issued in my favor. But since that work is not being implemented by the respondents, that is the state, I'm facing a lot of difficulty, my lords. So I filed a contempt proceedings. So matter would be taken up, my lords.
But it will be listed once you remove the objections.
My lords, the objections has been complied, my lords.
Then wait for 3-4 days.
My lords, it's still not come up after even complying. My lords, it's not so urgent that my lords.
Then our date will be not, our date will be longer than that. So we'll 4th of February.
Yes, my lords. 4th of February, I'll know it's coming. Sure.
My lords, in item number,
Regarding to the LB matter, my lord, single bench has partially allowed dispose of the matter, my lords. The matter is regarding to the fixation of the tax, my lords, the Gram Panchayat. I seek my permission to next week read it tomorrow.
No urgency.
My lord, but the respondents is filing the contempt, my lord, that's why.
That is not.
Next day,
28th of February.
next week, my lord.
28th February.
my lords, in item number 25, the arguing counsel is not in station, my lords. It may kindly be taken after 2 weeks.
35.
25, my lords.
25.
Writ petition 4271.
So when shall we keep?
After any time after 2 weeks, my lords.
After 2 weeks? 3rd March.
Much obliged.
Your lordship, serial number 20.
20.
Seniors, some ceremony is there in his house.
So then there is a delay, will issue notice. Notice returnable on 3rd March.
Much, much.
Already issued. All right, then 3rd March, simply
Much.
3rd. Send out to 3rd March as requested by learned the appellant.
Serial number 28, time for complainant on contempt matter, a week's time may be granted.
28 weeks time, it will go to 3rd February.
Grateful, my lord.
Any other mention through VC, sir?
But 39, not to be placed before the bench where one of us will duplicate. Honorable Mr. Justice M.I. Arun, take it over. He is a member.
Sir, contempt matters, seal number 1 to Balraj AC.
Notice returnable on 3rd March.
Please.
Seal number 2.
We filed our complaints.
It is complied with.
Please, madam. In this case, complaints affidavit, hard complaints, madam.
Pardon?
Complaints affidavit, hard to copies forward, madam.
Give copy. Now we'll help you. Go to paragraph
This case, madam.
3. last line. On page 2, the application filed beyond so and so cannot be considered. For instance, complaint file form number so and so so and so. Endorsement is duly served on the complaint. It is served.
Copies for madam.
No, endorsement is already served. The only direction of on a single judge. The order dated 10th March 23 was to this number 4, who was directed to consider form number 53 filed by the petitioners and pass necessary orders within stipulated time. Post of a compliance affidavit is filed, in which it is stated by the deponent member secretary of the land grant committee that the application of the complainant was routinized. Full stop. The amendments paragraph. Further amendments read as under. So this page, paragraph 3 you say on careful consideration. वहाँ से लेके endorsement to the complainants. Paragraph. It was further stated that the said endorsement, which is produced on record of, which along with the complaints was also served on the complainant. Full stop. Copy of the affidavit is served to counsel of the complainant, which includes the copy of, which also includes the copy of the endorsement of the order. Therefore, paragraph. In the above, the directions are complied with as the directions of learning single are complied with. The contempt petition is disposed of as not serving. Paragraph. If the petitioner has any grievance about the merits of the endorsement, comma, it is open to the petitioner to institute appropriate separate proceedings in accordance with law, comma, in respect of merit of which, however, this court does not express any opinion.
Please.
Seal number 3, to Sridhar ji.
Additional.
Notice returnable on 4th March.
Seal number 4,
Notice returnable on 5th March.
seal number 5,
Time notice 5th March.
The connected matter is posted on 28/2, madam. It's same
28/2.
28.
28/2.
28/2, madam.
28/2. Notice 28/2.
Great.
seal number 6, Mr. Manjunath Bihar.
I represent the complainant. But the order passed by the single judge is at annexure D, page number 72, madam.
Your father,
Please, madam, I am the father. I was given the visitation rights over the children. But the respondent number 1 and 2 are not giving the visitation rights as per the order passed by the learned single judge.
what is the age of the, what is the age of the children?
But
Female child,
please, madam,
named Amaraya Fatim, and second female child, Aramine Fatim. They are where? In Saudi Arabia.
they were in Saudi Arabia, madam, earlier.
Now here,
No, here, in the custody of respondent number 1 and 2,
1 and 2 are the grandfather.
grandparents.
Notice returnable.
But notice to respondent number 3 to 5 may kindly be dispensed. They were just formal parties.
Notice returnable. This one number 1 and 2, against whom the contempt is alleged.
But
Writ
apart
comma
from,
return.
apart from that, my lord, I may be permitted to serve the copy of the contempt petition on the counsel who is appearing before the trial.
Returnable on. When shall we give? 30,
Any short date,
huh?
any short date.
29th January. Also,
Please.
in addition to the normal word of service, comma, it will be permissible for the learned of the petitioner to serve copy of this contempt petition to the counsel
Please,
who appears for this one 1 and 2
please.
in the trial court.
Trial court,
In the trial. Trial court, they will not come here anyway.
please.
Next,
seal number 7, to MS Devraj.
not notice returnable on 3rd March.
Time is not stipulated in this matter. Time is not stipulated in this.
Not stipulated. How can I miss it? I missed it. Time is, there is no time limit stipulated. While allowing the writ petition by order, while allowing the writ petition by order dated 19th August 24, learn a single judge directed Rich number 2, Tehsildar, Tumkur district, Turu Vekre Taluka, Tumkur district, to consider the representative petitioner in accordance with law. Paragraph. A reading of the order, a bare reading of the order indicates that the purpose of consideration representation from a learned single judge is not described in time limit. Paragraph. In that view, at this stage, it is not possible for the court to conclude that the respondent concerned has committed any contempt, much less a willful contempt. At the same time, paragraph, the direction of the court should not go uncomplied with. Therefore, while disposing of this contempt petition, it is provided that respondent to Tehsildar shall decide the representation dated 30th 3/24 of the petitioner within 6 weeks from today. Full stop. With such observations, the contempt petition. Before heard, learned advocate, please. What's your name? Good name.
Sahana.
So give the name, so and so for the complaint.
So writ appeal matters, seal number 8, Mr. Prakashyam.
For the appellant,
Number 5.
the appellant, the father of the appellant, my lord, purchased the property in the year, my lord, 1966, my lord. In land in survey number 168/2, my lord, measuring 1 acre 80 guntas. Usmanabad village, Jalahobali, Bangalore, North Taluk, my lord. After the purchase, my lord, got effect in mutation, RTC in the name of the father of the appellant. Then, my lord, the father died on in the year 1988, my lord. The,
Deputy Commissioner refuse your request for mutation.
yes, my lord.
Refuse your request for mutation.
Yes.
Based on the
You
sale.
already filed civil suit for 519.
The civil suit is also rejected.
Dismiss for, my lord. Then, my lord, I prepared the appeal for the San Court, the appeal is pending, my lord. In RFA number 2127/23, my lord.
There is no error in the order.
The order 7, rule 11D application, my lord, allowed and reject the plaint, my lord. Then I prepared a appeal before the San Court, my lord. Appeal is pending. The respondent number 4, my lord, the question in the year 2017-18, my lord, more than 50 years. But till today, my lord, I am position on cultivation in the land, my lord.
Heard learned advocate so and so for petition appellant. Learned additional government advocates.
Respondent number 1 to 4, my lord. 1 to 4.
I represent respondent on 5
1 and 2, 1 to 4.
1 to 4.
Whereas learned advocate Mr. So and
or R5.
learned senior advocate Mr. So and so for respondent 5. The present appeal is directed against the judgment directed in order dated 13th June 24 of learned single judge whereby the petition was dismissed. The appellant petitioner paragraph in his writ petition sought to call in question the orders passed by the deputy commissioner, confirming the order of the assistant commissioner whereby the prayer for mutating the entry in the revenue records was refused. The petitioner happens to be the owner of the land in question. Father of the petitioner was the owner of the land in question, which land was sold in favor of the husband of respondent 5 by registered sale deed. Full stop. It appears that mutation was effected in terms of the registered sale deed. Subsequently, the petitioner filed original suit number 519 of 23 and asserted their ownership right, which suit came to be rejected under order 7 rule 11 of the Code of Civil Procedure 1908, and the same is subject matter of regular first appeal. Full stop. When the parties are already before the civil court agitating their right, and the issues of title and ownership are involved to be considered. The revenue authorities were eminently justified in not entertaining the request for mutation of the entry. It is right that the mutation is only for revenue purposes and it cannot reflect the titular rights, or particularly when the parties are before the civil court. Full stop. No error could be noticed in the order of law in a single judge. The appeal is meritless. It is dismissed.
Okay.
Appellant Malad. Appellant depot manager Malad. On an allegation of misconduct Malad,
If I am fast, tell me. You are able to get dictation. Not, I am not fast. Yes,
Malad,
delay of 6 years.
5 years Malad.
How many time?
Malad. In fact, Malad, he was kept under suspension for 6
Got
months.
some dismissal. What was the penalty? Dismissal.
Penalty, not dismissal Malad.
So then what was the penalty?
Penalty is Malad, one of warning and suspension period treated as not on duty. Malad, he was kept under suspension Malad for a period of 6 months Malad. The inquiry officer held that Malad charges are not proved.
Punishment order, yes.
Yes, Malad. Without submitting, without serving the Sokas notice or dissent note Malad, the disciplinary authority Malad in final order disagree the findings of the inquiry officer and imposed the punishment Malad.
But then 8 years delay, 2016.
No, Malad.
Yes, the-
16 December Malad in the appellate authority order. February 2022 Malad writ petition Malad. Malad, in fact Malad, in between Malad, there is a COVID-19 Malad. For all these Malad, I explained the delay in paragraph 8 of my writ petition Malad.
Penalty is also not major, Mr. Chief.
Malad, penalty is Malad, you stand to lose 6 months increment Malad permanently Malad.
So 16, the COVID came in 20 only.
True Malad, the 2016 December Malad order passed Malad.
By filing this appeal, the appellant
Para 8 Malad, I explained Malad, delay Malad.
appellant as original petitioner seeks to call in, has called in question, seeks to call in question order dated, judgment in order dated 21st June 24 of law in a single judge, whereby the writ petition was dismissed. First of the writ petition, the challenge was advanced by the petitioner against the order of punishment passed by Respondent Urban Managing Director, Karnataka State Road Transport Corporation, whereby the petitioner was warned and treated, and his suspension period was treated to be not on duty. Full stop. The said order of punishment dated 9/2/16 was passed pursuant to a disciplinary inquiry. Full stop. While not entertaining the challenge, what weighed with the learned single judge was that the order of penalty was passed in the year 2016, and the challenge and the writ petition was filed after 6 years, after a gap of 6 years in the year 2022. Full stop. The ground which was advanced before learned single judge, namely that there is a COVID pandemic, that the currency of COVID-19 pandemic prevented the petitioner from challenging the order, and that the petitioner was transferred frequently from one place to another, was sought to be repeated before the court while assailing the impugned order. Full stop. Paragraph. Law in a single judge did not find the ground put forth for explaining the delay of 6 years. Full stop. The delay of 6 years is fairly long delay,
It comes 5 years Malad.
within which time the litigant ought to have be vigilant to be the time. 60 years period is a long time, which should be viewed as passing away of which should be viewed as indolent on part of the litigant. Full stop. When the reasons are not found acceptable by learned single judge, the appellate court, this court in appeal is not inclined to substitute its own view, more particularly when the COVID-19 pandemic was in the year 2020-22, whereas the order was passed in the year 2006. In any case, the lethargy and indolence on part of the petitioner is evident, full stop. No error could be booked in the order of learned single judge. The appeal is meritless, it is dismissed. Next.
Mr. Kalyan R.
Delay will issue notice. Notice returnable on 10th March.
Madam, one more submission.
Yes.
There is another connected matter, similar matter. Should be taken on both. Yeah, another connected matter is there.
So
WA number.
it is
what-
already on board.
No,
It is already posted on board.
no, madam.
Then
It is not posted on.
then what can be done? When it is posted, you mention. We'll keep together.
This is number 11. To HP Leeladhar.
With your lordship's permission, my lord, my lord, I'm not feeling well. I'm not feeling well, my lord.
Yes.
I appear, please.
Yes.
Purchase ಮಾಡ್ತಿರ್ತಾರೆ. ಹೇಳಿದೆ ಶೂಟಿಂಗ್ ಇವನ್ನ ಪಿಕ್ಚರ್ ಆದ್ಮೇಲೆ ಕನ್ಸಿಡರ್ ಮಾಡ್ತೀವಿ ಅಂತ ಬಿಟ್ಟಿದ್ದಾರೆ. ಹೇಳಿದಾರ ಹೇಳಿದೆ ನಿಂತು ಟ್ರಾನ್ಸ್ಲೇಟ್ ಕಾಪಿ ಹಾಕಿ
So died in your, who died? Father?
Lordship's husband died, your lordship.
Husband died in,
Died in 21/1/2015, your lordship.
and
My first wife died on 22/2020. Her son is also died on 3/11/2019. And the petitioner made representation on 19/1/2016.
reply was filed to the main petition.
Pardon?
In the main petition, statement of objection were filed,
No, not filed.
not filed.
The
The delay is a very good ground for deny the.
the honorable court has been rejected the application only on the ground petition. There is a delay, but you have filed in time, your lordship. Representation. In the, even the authorities is concerned also, your lordship, the brother of the deceased has filed a civil suit. After that, you are going to consider the representation.
Petitioner is a wife's first wife.
First wife died, your lordship, is
Second wife.
2020, 20th/2/2020.
Petitioner is the second wife.
Pardon?
Second wife.
Second wife.
I am second wife, your.
When the second marriage took place,
Second marriage took place, your lordship, your marriage registration also I produce, your lordship, ink page number 41, your lordship.
oh, well.
Registration certificate is also produced, ink page number 40, your lordship.
Out of wedlock. First wife died in 20.
20th/2/2020, your lordship.
So then you are delayed by 5 years in seeking the appointment.
I filed, immediately filed, your lordship. Allah, the husband died, your lordship, is 20th/7/2012. Yes. 2000, Narasimha died 2015. And myself has filed an application on 19/1/2016. Annexure A. your. In the in page number 30, there is a seal of the corporation, 22/1/2016.
What is your rules and scheme for appointment?
My lord, page number 40 may kindly be seen, my lord. BBMP has to,
Mr. Sanjeev, we are asking for time.
My lord, here, my lord, what has happened, my lord, he files the first wife, my lord, gets all the settlement. The settlement is given in favor of the first wife, and the first wife's son was nominee,
Then File,
and
file some.
I'll
some
file.
re- File some reply.
Obliged.
Reply shall be filed by respondent number 2.
Respond number 1 and 2 and 3.
Because in the main petition. All right, you appear and produce your rules simply. This is notice returnable on 5th of 6th of February
Obliged.
to be listed at 2:30.
Much.
On which date the respondents, counsel for the respondents will respond to the case put forth by the
Much.
appellant. Next. Yes. Learned advocate Mr. Harish
respondent number 1.
accepts notice on behalf of number 1, whereas learned advocate Mr. B.L. Sanjeev accepts notice on behalf of number 2.
2 and 3.
2 and 3.
Much.
This is number 12. Petan,
Your lordships kindly. Lord, the identical matters are listed on 30th. I have given the numbers also.
When it is listed?
30th.
30th January.
30th.
30th January.
This month.
Yes.
Yes, ma'am.
Notice has to be ordered in this matter.
In this case, this is
I accept notice for respondent number 5.
and so far as other respondents are concerned, my lord, may I request your lordships to permit me to serve copies of writ appeal on the council appeared before the learned single judge.
Since
Because-
it was stated before the court that the similar appeals are slated to be listed on 30th January 2025, there shall be notice in this appeal returnable on the same date. Learned advocate Mr.
Kumar MN minutes.
Kumar
MN for respondent number 5.
accepts notice on this number 5. The rest of the respondents shall be served. The service to the rest of witnesses may be effected through normal mode of service, and in addition, appellant is permitted to serve copy of the appeal to the counsels of the said respondents who appeared before learned single judge.
Mr. Rajendra MS,
Obliged.
please.
this is number 13. Allur Shivayogi.
This case I am appearing for appellant. I have challenged the order passed by the learned single judge dated 6th August 2024.
So ombudsman say that settle the insurance amount.
Please, my lord.
Why should we interfere?
My lord, the policy is a G1 Sarar plan. G1 Sarar policy took by the respondent. And the plan of the policy was, if in the enforce of the policy, during the policy, if death is occurred, he will get the 10 lakhs. Or any accident is happened, then is a 10 lakhs rupees liability on the corporation. And after maturity, as per the terms and conditions of the policy, we have to pay the premium, return the loyalty bonus plus premium, whatever he has paid. Kindly permit me to produce the plan of the policy, my lord.
Is the ombudsman who will be better appreciating?
No, but the terms and conditions of the policy has not been looked into, my
We are
lord.
not going to reappreciate the terms and conditions. Ombudsman is specially created incumbent for that purpose, and he has appreciated and directed lump sum amount to be paid.
No, my lord, kindly pay 61, my lord. See, as per the terms and conditions of the policy, we have calculated and maturity claim as payable to 1,74,362. But the respondent contention is sum assured on maturity is 10 lakhs. And ombudsman has passed an order to pay the balance difference amount. For against which I have prepared a writ petition, and that is also dismissed. And the entire plan of the policy has not been considered.
You have survived.
Yes, survival. This. It is a unique policy, my lord.
Notice returnable on.
I pray for stay, my lord, because within 8 weeks,
We'll see if some contempt is filed. 10th of March.
much.
Number 14,
My lord,
appeal by state.
government appeal, my lord, there's a delay of 102 days, my lord, delays them.
You are for the
Government appeal, my lord,
appeal of the state.
please, my lord,
So notice returnable on
please,
11th February.
grateful.
Number 15. Mr. Rajesh Tikar.
I'm for the appellant in this case, my lord. A week's time may be granted. My lord.
Why?
Council is on record, is not in station, my lord. That's it.
Council is not. You dismissed cashier.
Yes, my lord,
What is the ground?
that ground that, my lord, the criminal case,
And you are
initiated.
arguing.
So, in criminal
You are
case,
well aware about the matter and ground and merits.
in subsequent, my lord, additional document produced.
So
In
you have forgotten your senior?
I am going to engage, my lord,
Going to engage.
a senior counsel.
Then you engage and then brief and then I will be in some other matters, traveling, not. When do you? 11th February, as requested by learned every appellant, please.
Number 16, Mr. Srinivas K.
Lord, for the cavator respondent, my
Appellant.
lord.
I pray for the appellant, Lord, this is a
Appellant
case,
is
my lord, wherein the appellant workman, my lord, was working as a FD party under the respondent management. Lord, it was alleged against the appellant, my lord, that he had committed a theft of oil sachet during the course of, my lord, completion of his duties on 13th of May 2015. Lord, the charge, my lord, was resulted in dismissal after holding an inquiry. The appellant, my lord, has challenged the order of dismissal before the labor court. And before the labor court, my lord, the labor court had, my lord, conducted the detailed inquiry, my lord, and had come to the clear conclusion, holding that the charges alleged against the appellant has not been proved. Kindly take, my lord, the award passed by the labor court. My lord, at page number 202, my lord, annexure P. The finding of the labor court, my lord, holding that charges are not proved, my lord, is forthcoming at page number 242. The last paragraph of the award, paragraph 25.
appearing, is appear, respondent. Yeah,
They are already served, my lord.
Aviator has. He is there.
Yes, my lord, is there.
But the learned judge has gone into all aspects of the matter, the case law on the point. And but one other submission. Not and that is. May I make submission, Lord? The workman has been paid about 19,74,900 as 70 wages from 1/12/2019 to 30/11/24 and gratuity of 5,04,000 in addition to settlement amount of 77,090. In all, about 25 lakhs have already been paid to the workman subsequent to his termination. Now, my lord, once again, my learned friend says there was no CCTV in the kitchen, How could you say he stole the oil? There should have been CCTV in the kitchen also. Though there was a CCTV at the security and it recorded how this workman behaved when he was caught with the oil. Now the learned judge says there is no need for CCTV at every place. And moral evidence is there. And therefore, the learned judge says it's not the quantum of oil or quantum, money quantum that is important. The act of theft is what is important. Therefore, in spite of that, substantial relief was being given. And before this court, I have paid about 25 lakhs already.
Make confirmation. Kindly see the award, my lord, passed by the Labour Court. Labour Court, my lord, had examined the entire, my lord, for inquiry the proceedings at length, my lord, and after detailed and thorough examination of the with evidences, audits from both the sides, had come to the clear conclusion holding that the charge is not proved against the appellant. Kindly take, my lord, for a moment, my lord, one paragraph of the award, my lord. I will just read for your lordship kind consideration. Para 242, my lord.
Page?
Maybe. Therefore, it is clear that under the above circumstances.
Which page?
My lord, 242, page number 242. Annexure P, my lord.
So what is it?
It's a part of the award, my lord, passed by the Labour Court. My lord, in the sixth line from the top, my lord. Therefore, it is clear that under the above circumstances, the findings at Exhibit M7 is perverse, and also that the action taken by the second party management is illegal, unjust and arbitrary, and liable to be set aside. And therefore, it is clear that the first party is able to prove that the impugned order of dismissal is illegal, unjust, and arbitrary. And on the other hand, the second party failed to justify the order of dismissal on the alleged misconduct. The first party therefore is entitled to relief as paid under para 15 of his claim statement. Accordingly, issue number 1 and 2 answered in the affirmative. My lord, when the Labour Court, my lord, which is the fact-finding authority, my lord, which has examined, my lord, conducted the proceedings at length, after thorough examination and, my lord, appreciation of the evidence, he had given a clear finding holding that the charges are not proved. But learned single judge, my lord, holds on the ground that the charges have been proved, and the Labour Court has granted the relief by exercising the powers under section 11A. It is virtually incorrect, my lord. My lord, there was no occasion for the Labour Court, my lord, to exercise 11A, because, my lord, the 11A comes into picture only when the charges are proved and when the Labour Court has to modify the quantum of punishment. Here in the case, my lord, the Labour Court has clearly held that charges are not proved. So question of, my lord, exercising the powers under 11A did not arise at all.
No, that is not correct. That only charges are proved, then 11A will come into it.
Pardon?
That is not a correct proposition.
No.
That only if charges are proved, then 11A will come into.
My lord, section 11A, my lord, provides for the imposition of minor punishment by the Labour Court. Labour Court, my lord, can exercise the powers under section 11A if the charges are proved. Because, my lord, it has to, my lord, grant the relief by looking into the quantum of punishment. If the quantum of punishment is, my lord, more, then, my lord, it can modify the punishment order by imposing, my lord, minor penalty. That is, my lord, the 11A comes into picture only when the charges are proved, not under other circumstances. Here in the case, my lord, the Labour Court has held that charges are not proved. Hence, my lord, the 11A did not come into picture at all. But on the other hand, my lord, the learned single judge, my lord, comes to the conclusion that the charges are proved and the Labour Court ought not to have exercised the 11A powers. So hence, my lord, the interferes with the award passed by the Labour Court. So that is virtually, my lord, and in the instant case, my lord, the security guard, my lord, who has, my lord, was the only eyewitness in the incident. My lord, he had clearly stated that there is no proof as to show as to from how the oil sachet was placed in the vehicle. My lord, it's not the case that, my lord, the appellant was carrying the packet in his hand or in his bag. The packet was placed in the bag, the vehicle, which was parked outside the, my lord, in the parking slot. My lord, even the, my lord, supervisor who had worked with the appellant, he had closed the, my lord, the stores. And there is no, my lord, the allegation of shortage of the oil sachet in the, my lord, the cooking section. The supervisor has never alleged that there is shortage of oil sachet. The specific case of the appellant is that, my lord, somebody, my lord, who was inimical to him have placed the oil sachet in the vehicle. And the security guard, my lord, had checked the vehicle, my lord, and except the vehicle of the appellant, no other vehicle was checked on the said day. That is the specific, my lord, statement given by the MW6, who is the security guard. So in this, my lord, it clearly goes to show that just for victimizing the appellant, my lord, somebody had placed the oil sachet in the bag, in the vehicle. So this is a clear case of, my lord, victimization, my lord, and even assuming that, my lord, the appellant, my lord, is guilty of the charge, the dismissal or the order of punishment, dismissal punishment, my lord, is highly excessive and arbitrary. And even before the, my lord, learned single judge, there was a, my lord, a suggestion for settlement of the, my lord, the matter. And we had given also our proposal, but that was not accepted by the management only on the ground that they have paid the 17B wages. My lord, 17B wages, my lord, are payable because, my lord, the award passed by the labor court was stayed. Otherwise, I would have discharged my work and they got the salary, more salary than what they have paid me.
Yes, Mr. Counsel, what do you say?
But as I submitted minutes, the learned single judge has come to the conclusion that saying that there is no CCTV in the kitchen and therefore the charge is not proved is what the labor court says is incorrect. There is no need for at every place to have CCTV. And moreover, he says somebody has kept it in my motorcycle. Who is that somebody? Tomorrow everybody can say the same thing. Somebody has kept some oil in my motorcycle and therefore I am not responsible. If you are not responsible for your motorcycle, who is responsible? And this doesn't happen in any other case. If that is so, it could have been in so many cases. And he is now already 55 years. And I have paid him more than 25 lakhs. What more does he expect from me, my lords?
25 lakhs is not paid, my lord. Only 18 lakhs, my lord, paid as the 17B wages during the pendency of the writ petition for about 5 years. So that is, my lord, the mandatory provision which has been complied with by the respondents. Since the award passed in my favor, my lord, was stayed, so I am entitled for 17B wages that has been paid by the respondent, my lord. That is not a ground to, my lord, deny the benefit to me. Even assuming, my lord, that the relief granted by the labor court is the more, my lord, I was already, my lord, expressed my readiness to forego the back wages also, provided I am reinstated into service with other benefits. So, my lord, the workman, my lord, is already age board and is without employment. And, my lord, they have clearly a case of victimization, my lord, on the part of the respondent management.
So 1 liter sachet of the Truffle brand oil was found to have been committed theft of. So, Mr., is it possible to rethink on your part about the extent of penalty?
Pardon me?
Is it possible to retake the extent of penalty? Retake the extent of penalty. Retake. Kitchen.
On a charge of theft, the appellant was dismissed from service. The labor court set aside the dismissal, directing reinstate of the appellant workman with full back wages. When the paragraph paid judgment and award of the labor court was challenged by the employer, learned a single judge took the view that it was not permissible for the labor court to substitute the penalty of dismissal, and that it was not disproportionate to the nature of misconduct. Paragraph, the petition was accordingly allowed. Paragraph, while assailing the impugned judgment and order of learned a single judge, allowing the petition and setting aside the judgment and award of the labor court, from a learned advocate, Mr. So took the court view the record of the case, more particularly the judgment and award of the labor court, to submit that the finding of the labor court was that there was no theft, and also that the inquiry officer has not appreciated the material evidence resulting into recording of perverse finding. Full stop. It was sought to be submitted that the case turns out to be a case of no evidence, or of the evidence of the nature which is not legally tenable. Full stop. The appeal deserves to be admitted. It is admitted. It shall be listed for final hearing on 11th March. Obliged.
Cell number 17, B. Ramesh.
Delay.
Delay 72 days, my lord.
Notice.
Also, I'll be.
Passed by your lordships, my lord, page number 31. Page number 31 is passed by lordship.
Page 31, what is that?
Order dated 23rd August 24.
Impugn order.
Order, my lord, it's an order refusing to recall.
No, page 20 page.
No,
Not this case.
Which one?
not this case.
Sorry, my lord.
It's not this case. Notice returnable on.
My lord, so I may be permitted to take out, serve the answer summons on the advocate appeared before the learned trial judge. my lord.
Returnable on all letter.
My lord, so
24th February,
first before that, because
in addition to normal mode of service paragraph, learned advocate for the appellant is permitted to show copy of the appeal and the civil application to the counsel who appeared before learned a single on behalf of the respondent.
yeah. Or so it could be taken up in second week of February, my lord, for this reason.
Second
lord,
week of February, 19th February.
Much away.
So ready in notice matters. Cell number 18, Sir Appeal Mr. M.C. Basuraj. With HR Renuka.
Nobody is there, then let it go to 19th February.
Cell number 19, Mr. Kalyanar.
For the respondent number.
There is one more connected matter. between the very same parties, the same issue. My lord, in writ appeal number 1135/2020. Maybe this appeal may be posted along with
1135/24.
24.
My lords, this matter is quite different from that subject matter because this is regarding an increment that he is seeking, which is attained finality before a learned single judge prior to the impugned order, my lords. That is a different issue regarding the employee. It is not the same subject matter as my respectful submission. I appeal for the corporation, my lord.
Lord, with
Respondent.
regard to the, my lord, anomaly in payment and also non-payment of certain dues, my lord, to the employee.
Para 3 and 4 of the impugned order, my lords, at page 20 and 21.
The
Yes.
Earlier,
The
there's already an order passed in favor of the petitioner in terms of which, my lord, the salary of the petitioner was stepped up on par with the junior, and the arrears were paid for the preceding 3 years. 2004, the petitioner attained the age of superannuation, my lord. So the preceding 3 years, this has already been done. In fact, contempt proceedings are also initiated, and the contempt proceedings were subsequently dropped, my lord. So whatever amount was to be paid, that benefit is already given to the petitioner and he has accepted that. Pursuant to that, my lord, this is the second writ petition wherein the petitioner preferred, and the learned single judge considered.
What was prayed for in the second this petition?
In this, my lord, the endorsement at Annexure F, page 63 was
the
questioned.
gist of the matter is this, my lords.
Yes. What was the question is
In the writ
further benefit?
further benefit. He is seeking for benefit from 1986, my lord.
And
But
the learned single judge says that
it can't be given because in terms of the circular,
earlier it was already
It
accepted.
was already.
and he has accepted that, and he's taken the benefit of that order. And now once again seeking from 1986 is not permissible in view of
Estoppel.
estoppel.
Stop. And as a suit of recovery also, my lords, 3 years is the limitation. Therefore, his representation, my lords, the crux of the issue, the dates are this. 2002, a similar employee, my lords, one
May I draw your
Sridharan.
person's attention?
2002, another employee by name Sridharan was stepped up pay. He's asking on parity, my lords, that the same employee who got Mr. Sridharan, who got his stepped up pay, he should also be given. No doubt, my lords, he's on the similar standing. That 2002, my lords, the representation was filed by the appellant only in the year 2008, after span of 3 years. In a suit for recovery also, my lords, for recovery proceedings, the limitation would apply for 3 years. So 2002, which was right, which benefited to him, accrued to him, he filed a representation in 2008. This, the learned single judge in the year 2013 itself, 2011, my lords, records all of this and says, even though it is barred by limitation, give him the benefit of 3 years. from the date he attained superannuation. He attained superannuation in the year 2004. So prior to 2004, whatever his stepped up pay was, give that arrears to 3 years of arrears to him. It is recorded. The submission of the corporation was recorded and disposed of. That attained finality. It was not challenged. Thereafter, subsequent writ petition is filed, asking for pay from 1986 onwards. That the learned single judge records the earlier single judge's order and the circular and says whatever has been given to him is correct. Nothing more he is entitled to. This is the crux of the issue.
Lord, Lordship may kindly for a moment, page number 61, my lord, contempt proceedings. The operative portion, my lord, page number 62. There was a liberty given to the petitioner to challenge the endorsement. Without looking into, my lord, considering this order, learned single judge, my lord, has passed the order. Last 3 lines, my lord. Therefore, the complainant is given liberty to challenge the endorsement
So
by
then
separate proceedings in accordance with law.
which endorsement you challenge?
My lord, annexure F, my lord,
17.8,
page number 63.
17.8. 17.
During pendency of the contempt petition, my lord,
7.8 or 17?
7/8/2012,
17.8.
annexure F.
the issue is would be, my lord, whether on the ground of limitation, the claim of a retired employee could be denied. My lord, limitation would be applicable. My lord, my lord, if there is any anomaly in pay scale, my lord, the employee would be entitled, my lord, cause of action is recurring cause of action. My lord, I may be, the arrears would be restricted on the ground of limitation, not my claim. My lord, anomaly, my lord, my junior was given higher salary than my lord, the appellant. I am requesting that, my lord, not more than that. My lord, from the date of my demand, my lord, prior to the date of demand, prior to 3 years prior to the date of demand, my lord, I am entitled only under the limitation. But my entitlement cannot be denied. My lord, the other connected matter, the date.
Did you join?
My lord, date of joining, my lord,
1974,
my lord, 1974.
Thereafter, you became a meter reader when?
My lord, thereafter, my lord, as on 24/6/1982, the appellant was given next higher pay scale as junior engineer.
Junior engineer, huh?
24/6/1982.
Then Sridharan became junior engineer when?
My lord, he was appointed subsequent to the date of appointment of the petitioner.
Same
That
post.
is on 1/4/1986. And his pay was refixed higher than that of the appellant.
He was appointed as junior engineer only.
Junior, not junior engineer. Junior engineer. My lord, my appointment was in the year 1974. My lord, the appellant had, my lord, more service, put in more service than Sridharan. His, my lord, his pay scale was, my lord, revised higher than that of the appellant. Therefore, he made request to the respondents to, my lord, correct the anomaly. My lord, this anomaly occurred, my lord, in the pay revision. In the pay revision, my lord, the seniors should have been, my lord, given parity on par with the, my lord, their juniors, at least in the payment of salaries, my lord. That was not considered. My lord, the appellant, repeatedly had approached from the date of the anomaly occurred, and he had given representations. And now, my lord, pursuant to the directions of the Honorable Court, this Honorable Court,
Then
Well-
you preferred writ petition.
writ petition, there was a directions issued, and subsequently contempt. My lord, writ petition number 10030/2000.
100.
30/2000.
What was the order?
My lord, order was, my lord, page number, lord,
Page 41.
41.
Page. Page 41 and the next.
40. 41. my lord.
Remitted back for
Reconsider.
reconsideration.
Lord, the operative portion, page number 43.
Hmm.
In these,
Then endorsement were issued.
matter was remitted back, and my lord again, and my lord, endorsement was issued. My lord, which was challenged. My lord, in WP, my lord, which is at page number 56, my lord. 5898/2009.
Para number 3 you read.
Please, please,
That's where the problem comes in for you.
please. Though the learned counsel for the respondents had initially resisted the present petition, on the further assertion of the petitioner that the anomaly that was complained of was created in the year 1986 itself, and the comparison sought to be made by the learned counsel for the respondents to pay up the petitioner and the said Sridharan to point out that the pay of the petitioner being more than that of the said Sridharan is misleading, since there was indeed an anomaly even prior to the dates mentioned by the learned counsel for the respondents. Thereafter, the learned counsel for the respondents, having obtained further instruction, brings to the attention of this court an order dated 6th July 2009 under similar circumstances where the comparable employees have been given time-bound increments, by virtue of which, if such an employee is drawing a larger pay than his junior, the pay of the senior requires to be stepped up and accordingly. He would concede that so far as the petitioner also, such stepping up is warranted for a period of approximately 3 years, the details of which shall be worked out in due course. And he submits that the respondent shall pass appropriate orders to step up the pay. Recording this submission, petition stands disposed.
This you accept. you don't
Thereafter,
appeal.
my lord, contempt petition was filed. Contempt petition was filed. During the pendency of the contempt petition, my lord, an endorsement was issued. My lord, this endorsement, my lord, your lordship may kindly the operative portion of the contempt petition order, my lord, page number 62. The respondents have given step up in the pay scale 3 years prior to the date of representation. It is the contention of the complainant that they should be given step up from the date of anomaly. What I am seeking is stepping up shall be from the date of anomaly, and arrears shall be restricted for a period of 3 years. That's what the Supreme Court says, my lord.
Stepping up, you agreed in the.
My lord, that is the
petition,
concession made by the respondents before the learned single judge.
Recording that
Your lord, may I read, my
petition
lord?
was disposed
May I
of.
read, once again, read the order of the learned single judge, my lord?
Yes.
He would concede. That is not the petitioner, respondents
Fine.
concedes that insofar as the petitioner, also such stepping up is warranted. Warranted for a period of,
That was the concession given by the respondent.
Respondent.
Your employer.
please, my lord.
Okay.
Stepping
Now,
up,
the writ petition was disposed of in terms of the said concession.
my lord, your lordship may kindly further concedes that so far as the petitioner, also such stepping up is warranted for a period of approximately 3 years. Stepping up cannot be, my lord, restricted. My lord, from the date of anomaly, he would be entitled to receive the stepping up. But what can be restricted is
Now, counsel, we are
the
just,
payment of arrears.
No. We are analyzing the effect of this particular judgment on your rights. Now,
Yes.
you are the petitioner over here. Now, this particular writ petition was disposed of by granting you a particular relief. This
Your
writ petition was disposed of granting you a particular relief.
Your Lordship may kindly further permit me.
This writ petition was disposed of granting you a particular relief. And you did not file any appeal against this particular writ petition. Now, because even this was not implemented, you filed the contempt petition. Contempt petition was filed to enforce the undertaking given in this writ petition and not something more than that.
My Lord, during pendency of the contempt proceedings, endorsement came to be issued. There was a liberty given. My Lord, the restriction shall be only for payment of arrears.
In all cases, in every alternative case, we say that if you are aggrieved by endorsement, you are at liberty to challenge the same. That's what has been said. No special right has been conferred on you. Yes, liberty was given to challenge it, provided the endorsement did not fulfill the order passed in this particular writ petition, not over and above that.
My Lord, such a concession given by them, if it runs contrary to the law laid down by the apex court. My Lord, what apex court says, my Lord, from the date of anomaly, the employee would be entitled for receiving, my Lord, stepping up of pay scale and revision of pay scale. But for payment of arrears, seeking of arrears can be restricted on the ground of limitation, not stepping up. I am seeking only that.
No, stepping up has been done.
Stepping
from
up is
86.
only I am
Kindly
seeking up.
see page
seeking
number
for
88. for-
Stepping up.
My
Now,
lords,
my Lord, by virtue of, my Lord, not revising the pay scale as per the, my Lord, the request of the petitioner. Now, my Lord, he is receiving, my Lord, the pension, lesser pension now. What he would be entitled would be, my Lord, if his request is allowed. He is entitled for revised pension, pensionary benefits.
But what was paid to you and what was agreed by you was a consequence of stepping it itself.
yes. Stepping up was done from 86
Correct.
with that other gentleman, my lords. And then whatever is the arrears, only 3 years has been given. That also compliance is
It
at
is
88.
consequences
Page
and
88, I've
orders
given a
are
comparison table.
To the stepping up itself, you accepted to limited extent. Now you are trying to re-agitate from the anterior date.
Lord, and
He's
already
asking arrears from 86, my lords. That is the prayer.
in the earlier round of the writ petition also, his prayer was from 1986, which was not considered by the learned single judge.
In the earlier, this one, page
Yes.
60.
Page 59, what
Yes,
my lord
yes.
was read out.
The
And there
amount-
also at line 3, it is mentioned that the petitioner's complaint, the anomaly was created in the year 1986 itself. So whatever the grounds now which the learned counsel is arguing, that was raised in the earlier round. And one more aspect, my lord, we are governed by our circular. Our circular restricts us only for providing for 3 years. This circular is not challenged by the petitioner either in the earlier round of litigation or even in the writ petition out of which the order has arisen. So unless that circular is set aside, we can't go beyond the circular, my lord, and give the benefit to the petitioner.
Dismissed.
Twenty is adjourned, number 21. SB Mukanappa.
2 weeks time may be granted, my lord. The earlier, my lord, I served the copy to the BS Sanjeev. Thereafter, my lord, the Srimati HR Renuka is filed the wakalat on behalf of R1 R2. Again, I will be served the copy to.
Asking if there is no objection, will condone the delay. Even if they have objection, will condone. But in their presence.
Yes.
Other day or in the second half?
Next month,
Next week, next month,
next 2 weeks, after 2 weeks.
13th February.
Number 22. Srimati Sudhadi.
Senior counsel is out of station. I'm seeking short accommodation, ma'am.
My lord, in this
For the respond number 4, Lord, should in this matter, Lord, should the
petitioner has suppressed the entire things. Earlier occasion, your lordship, the same similar writ petition already filed, similar writ petition already dismissed. They are suppressed, your lordship. I am produced that order copy along with my statement of objection.
The same subject.
Same subject. And along with that, in addition to that, your lordship, they are suppressed several things, your lordship. They are not filed this petition in accordance with the PAL rules, because your lordship, there are several FIR against the petitioners. I am also producing those FIRs, your lordship, along with my statement of objection.
My lord, the government has initiated action since they have encroached upon 2 acres of land. My lord, the education department has already issued notices. My lord, I'm producing a copy.
Your lordship, I am sorry to, your lordship, your lordship, when the matter is pending, your lordship, your lordship, the suit is pending. And your lordship, the suit for declaration is pending before the senior civil judge in respect of the same property. And there is, your lordship, injunction order is operated against. And you filed a writ petition before this honorable court.
You are for number 4.
And your lordship, when the matter is pending, your lordship, now your lordship, now government advocates made a submission that, your lordship, they are already issued the notices. In spite of, because of this public interest litigation petition.
My lord, the encroachment is for 2 acres of land in which
I agree,
they
your
have
lordship,
constructed
in
a
identical
school. My lord, suppressing
the
many facts.
school is running since from 35 years. Your lordship, kindly see, your lordship, your lordship, the permission given by the government. I am sorry to say, your lordship, kindly take annexure R6 page number 51.
My lord, I don't have a copy of the objection. Please give me a copy of the objection that you filed.
Madam, serve ಮಾಡಿದೆ already.
ಇಲ್ಲ ಅದು ನೋಡಿ ಹೇಳ್ತೀನಿ ನಾನು.
Please. You should kindly see annexure R1, your lordship, kindly take, your lordship, the identical writ petition already disposed by this honorable court. Page number 18. The, your lordship, the brother of petitioner number 1, he only himself filed this writ petition. Kindly take what is the findings, your lordship, page number 22, statement of objection. Para number 4. May I make request, your lordship? Page number 22, para number 4.
Page numbers.
22. Identical writ petition filed by one of the brother of petitioner. They suppressed these things before this honorable court. Para number 4. Page number 22. It is admitted fact that OS number 45190 is filed by the respondent number 5 for title and injunction in respect of the very property involved in the case hand. Petitioner filed application to get themselves implemented, which came to be rejected by the trial court, which again is confirmed by this court in CRP so and so. Contention of the petitioner regarding the trespass by the respondent number 5 and the right of the respondent number a disputed question of fact, which cannot be gone into the petition under section 227 of the Constitution of India. Moreover, suit is already pending on the very question in OS number so and so. In this circumstance, no relief can be granted to the petitioner in any of the pending proceedings in respect of the very same matter before the civil court. Hence, we decline to entertain this petition and the petitioner stand rejected. Earlier occasion, one of the brother of the petitioner, sought a similar relief, and your lordship, kindly see suit is pending. Kindly take, your lordship, I am also producing the entire order sheet of the suit. Kindly take, your lordship, the annexure R20, page number 174 in my statement of objection. Page number 174. In respect of same identical property, the suit is already pending before the trial court, and these people also implicated themselves as one of the respondents before the trial court. And they were already approached the land grabbing court in respect of same issue. There are parallel proceedings. Kindly take page number 174, Lordship. In respect of identical set of property, page number 174 of my statement of objection, annexure R20, 174. Schedule is 180, Your Lordship. And Your Lordship, in that suit, Your Lordship, you obtain the injunction order against the state government. Your Lordship, your possession of the property since from 40 years. My application is pending before the government to regularize the land.
It is same land,
Same land, your worship. Same land,
250.
same land. And your worship, kindly see, even the petitioner is admitting that your worship, there is injunction order. Kindly take your worship their petition. You kindly take your worship the writ petition, page number 8. The writ petition, page number 8.
And number 4, T. Krishnappa
Yes.
was, he is also here in this property.
Correct, your worship.
Same person.
Same person. Your worship, admittedly, your worship, their allegation is education trust is your worship the encroached property. Education trust is not a party before this honorable court. Your worship, kindly see what is the prayer in the writ petition for a moment. Kindly see, your worship.
Duties.
And 1 second, your worship, kindly.
What is your stand?
Surprised with the statement of objection which is not given, but we have initiated action, my lord, by the education department since it is running. My lord, we have sought
Because
for
of
a
this,
cancellation of their recognition also.
Who petitioners?
Respondent number 4.
So because of
And
this.
now taken by surprise when they are saying that there is a suit
Very
pending.
surprised, your worship, I filed a statement of objection.
My
your
lord,
worship, I
copy
thoroughly-
is not served on me, my
1
lord.
second, madam. David, kindly see your worship, accludement, your worship, kindly see accludement. I have served the copies to the government. I am served, your worship.
My lord,
Four-
kindly
4,
see
5
the
dash back.
annexure B, RTC. It shows is allotted to primary, Prathamik Arogya Kendra, primary.
And 1
health
second, your worship,
center.
kindly one for a moment, page number 10.
Yes. See, government,
My lord,
the entire case of the petitioner is that the property concerned is a government property.
yes.
My lord.
And respondent number 4 is running a school over there illegally.
Education.
That's the sum and substance of the whole thing.
Yes, sir, I agree.
If government is of the opinion that it's a government property and respondent number 4 is squatting on the property illegally, then you'll have to take steps in the manner known to law. And if respondent number 4 is desirous of filing any declaratory suit or something like that, he is always at liberty to do so in the manner known to law.
Yes, my lord.
We can't go into the title of the parties over here.
No, no. My lord, 2 petitions are pending
And
before
in
the
addition,
land grabbing court.
kindly see prayer, what is the prayer in the writ petition? For a moment, kindly see. The trust is not a party before this honorable court.
You want time,
Yes, my lord.
when your senior will come.
GK but,
Pardon? When shall we keep?
after 1 week, after 1 week.
After 4th of February. To be listed at 2:30. Since request was made by learned advocate Miss so and so for the petitioner that the senior counsel is not available for for his person. 4th February.
Oh, very well.
Much obliged.
Sir, Hemant.
Copy ಕೊಡ್ತೀನಿ madam. I will give one more.
Pardon?
December 23, to Jay Prakash Reddy M. December 23,
If nobody is there, then it will go to 7th February.
December 24, amputation fee.
Is it? A government building is a 45 years old building. A taluk office was there in Udupi.
Statement.
One new building was already constructed just behind to that building. And this building is under a dilapidated condition. As per the tender and all the sketch, everything is there. as a sketch is, it has to be demolished. That area has to be given for the parking and other things. The Karnataka Housing Board has taken this task. Fifth respondent has to make this as per the sketch only. Because now this page number 40, your lordship may kindly see, this is the dilapidated old building from the last 4 years. It is a vacant and it's not maintained properly. It is already decided to demolish it. In that area, the parking facilities has to be given. The map is in the page number 64, my lord. Your lordship may kindly see the sketch. Annexure E.
Going to demolish.
My lord, we need accommodation for government offices, considering the fact that Udupi is developing very fast. And we have to provide infrastructure, my lord, to the growing population.
No, this you are going to demolish. No.
Yes, we want to demolish, my lord.
Yes, my lord. Now, I want to make only one submission.
My lord, for
Annexure E and
a building, my lord, which requires 70 lakhs for demolition. They want that place for parking only for the purpose that, my lord, the mini Vidhan Saudha, my lord, the old Taluka building looks ugly in front of that Vidhan Saudha because it's situated right in front. And we are in need of offices, as I submitted to my lord, for providing infrastructure. I will argue the matter.
page number 74 may kindly be seen, my lord. How it is affecting. The advocates and also who are all going there.
This is for advocates parking you are asking.
Yes,
So-
that's
Not for advocates parking. Because
building saying that we need parking for advocates. This is the mentality, my
it is
lord.
not like that.
It is like that.
Lord, there is a report, my lord, saying that it is in good condition. No, my lord, so that, my lord.
I will argue it out, my lord. They're not entitled for it. And they cannot dictate to the government where we should have offices, what is to be done. There is a dearth of land and accommodation in Udupi, my lord. It's developing so fast.
You filed your.
Yes, yes, I have filed.
They have given their statement of objection, man. At least time I will file the counter and also.
See, in the light of submission made by you, that there is a dearth of space, probably you'll have to construct the buildings more scientifically, where the height of the buildings need not be 20 feet and all that. It can be limited to
My lord, this is a heritage building.
the floor, if you are constructing a new thing. Probably you can accommodate all the demands, even the multi-storied parking lot. It requires only an application of mind.
My lord, right, but my lord, considering that there is a dearth of accommodation.
Yeah, for that reason only I suggested this.
My lord, we cannot go around, my lord, constructing new buildings anywhere and everywhere. This is a heritage building.
Structurally safe.
Yes.
There is no report, just one letter is there. If the building, whether it is good in condition or not, they have to examine each and everything. One letter they have given. Prima facie, it is.
You are also simply saying that old building, therefore demolished.
Yes, yes.
No,
my
no,
lord,
not-
that is the
not
condition.
like that, my lord.
Nothing
If
else,
that
my
is-
lord, yes.
My lord, if that is the question, the annexure E and E1 may kindly be. Even the amount is sanctioned to the Karnataka Housing Board to make all those things. They have taken the money. Now they are standing along with the government. The certificate is already given because they can, whatever the money they have granted for the parking area and all other things, where it will go? It is a public money, my lord.
There must be a scientific or technical substantiation.
Yes.
What you say for demolition. Just saying demolish because it is old is no.
Yes, and there's the pressure also to get this building demolished. Though it is because.
The government
it is a added
stand is
building.
like that 75 lakhs. I may be ready to give the 25 lakhs and we will clear it.
We don't need
Yes, I am
charity,
ready,
my
my
lord.
lord.
We
If
don't need
that type of
charity.
stand they have
No,
taken.
no, we don't need charity. You come on the merits of the case.
Then
Yes, yes.
merits
No,
of the
no,
case,
no,
they
no.
have taken the money. Housing board has already taken the money.
You want to file count?
My lord, I have already filed. I will argue it.
He wants to file.
Very well.
When you will file?
After second, my lord, election is going. Sorry.
Lord, he has to get over the election fever also, my lord.
Second week of February.
I will not say anything about election. Second week of February,
Any day.
18th of February.
Much of.
Sir, 25 is adjourned. Number 26. Amrutesh.
It is with regard to the celebration of November 1st in all over the Karnataka, it touches the Karnataka Kannadigas. Where in Belgaum district, it is a border dispute is there. Some of the MES fellows, they are making it as a black day. It is started from the year about 20 years. This petitioner and other organizations are giving the complaints. They have not taken in. Even apart from that, the police are arranging for their bandobast to do this black day. Several complaints are filed. Petty cases are filed because November 1st is we have got our own some touching to this heart and soul of the Kannadigas. Last occasion also, after the interior, some order was passed on that day, this year, last year means 2024. They have done the procession. On 5/11, I have filed the memo, how they have conducted the black day. Some of the photographs and even the Marathi newspapers.
Who bring the protest?
This is fifth respondent. Fifth respondent, Maharashtra Ekikarana Samiti, they have appeared in their appearance.
We are representing my lords, respondent number 5.
He is the fifth respondent who is holding all this, my lord. Their appearance is there before the court.
Who is for number 5? Nobody appeared.
My lord, respondent number 5, they.
Respondent number 5, we are representing respondent number 5 in this case.
Who are you?
We are representing the organization called as Maharashtra Ekikaran Samiti, which is represented by its president.
Maharashtra in Karnataka. Hi, what is your stand? Make it clear. Notice returnable on
All are served, man.
20th February.
Much of.
Obliged.
Much obliged.
Reply shall be filed by all the respondents.
Very much obliged.
Earlier it is no notice is no notice. Other bench.
Lord, on 30th October 2024, notice had been issued to.
Notice has
Oh, they only say that notice is already issued on 30/10/24. The subject matter and the cause raised in this public interest petition awaits response from the, awaits a reply from the respondents. The affidavits of reply affidavits of all the respondents before the next date stand over to 18th February.
much of.
Number 27.
You have to wait.
Deep Nayak.
Here for the petitioner, my lords, this is the matter relating to the Preservation of Trees Act. I had filed an IA on 20th of January regarding an official memorandum that has been uploaded on the BBMP's website, in which they want to fell. This is IA number 8, IA number 2, my lords, of 2025.
So what do you want?
An official memorandum has been put up with a direction to fell about 538 trees. And this OM is in complete violation of the orders of this honorable court. No order has been uploaded of the expert committee which was appointed by this honorable court. The details of translocation and compensatory plantation are not in accordance with the orders of this court. The trees which they seek to do as compensatory plantation, they want to plant 45 kilometers away, outside of Bangalore, outside of the jurisdiction of BBMP, in a completely different taluk, in Nalamangla taluk. My apologies. In similar circumstances, your lordships have granted us interim protection until they file their objections. Through two IAs of IA 2 and 3 of 2024 in June and July of last year, similar protections were granted to us.
Where is that memorandum?
It's produced along with my IA 2 of 2025. The OM is at page 23, Annexure A. And the schedule your lordships would find at page 29, where they want to fell 530 trees.
This Command Hospital Air Force
Please, Lords.
is cutting the trees.
Please, Lords. We are challenging the BBMP order, the DCF order, which is not in accordance with the continued directions from this.
Where is the BBMP order?
This Annexure A is the order passed by the BBMP. Applications are to be filed by BBMP and BBMP has to pass the order. This is the tree officer of the BBMP.
This Deputy Conservator of Forest sits in the BBMP office.
As a tree officer, as a tree officer,
The tree office.
as a tree officer,
Capacity of tree office.
the tree officer.
In fact, one of the main grounds in the main writ petition is that that it should be separated out, because there would be a conflict of interest with the BBMP wanting to fell trees, the tree officer wanting to
No, he is
protect
an
it. But that's a
independent of-
separate question, Manoj.
Under the Trees Act, he is in office.
Please, Manoj.
Only.
He's under the forest, he's under the
Correct.
forest ministry.
Correct. So file your reply.
No, I'm not in that matter.
I appear for the BBMP in that matter.
BAP, so BBMP, IAP and another
Copies may be
application.
served on me. They were sent it with the, find the counter.
We had served it on the 20th. I have no difficulty serving additional copies. Until then, let them not fell these trees, Manoj. 530 trees in the heart of the city.
So Prashant, am I required to answer?
Thank you.
No, this.
Why they are cutting the trees? Some project is.
They're expanding a hospital, Manoj. And I have said in my objections, I have no, the reasons are genuine and we have no objections against the development. It's only the process that needs to be followed as laid out by this honorable court. If they follow the directions of this honorable court, then that's all we are trying
Filing
to
this
protect.
interim application,
So Pradeep,
the
Government
allegation and the allegation is that
Government wants a copy.
the Command Hospital Air Force,
I have given my copy.
Bengaluru,
Given already one given. Okay.
Do we have
in the process of expansion of its setup. Is to proceed to cut
Yeah. it's what it is.
trees. And that the trees are being cut. The precincts and premises. In the, the trees are within the campus of this, precincts and premises of the hospital. It is the further allegation that the cutting of the trees that has been taking place in violation of the series of orders passed by the court in this public interest petition. And further in breach of the provisions of the. What is the Trees Act? What is the full name?
The Preservation of Karnataka
Preservation of-
Preservation of Trees Act.
Entire act name, full name.
now Uttara Pradesh.
Karnataka Preservation of Trees Act 1976 and Karnataka Preservation of Trees Rules 1977.
Yeah, Pradeep.
Law and advocate, Mr. What is your good name? For instance, appearing for
Prashant.
BBMP, raise time to submit the
Name.
the
SH
copy of the application is not served to him. Law and advocate for the applicant will serve the copy of the application. Paragraph. Replies will be filed. Full stop.
No, there is
Till
another
further orders, there shall be no cutting of trees.
There's
DP
another
application.
application, Lord, which is of some urgency, IA number 8,
IA number?
8 of 2025. Of 24, Lord. I'm sorry, IA number 8 of 24.
8 of 24.
This is an application filed by the Bangalore Metro, my lord. Now, the airport line that is connecting, my lord, the airport, we made an application to the expert committee and the tree officer for cutting of about 75 trees. After evaluation, the expert committee has instructed that we must retain about 15 trees on site. 5 trees have to be translocated and 55 trees can be removed. That report is now, my lord, available before your lordships. May I request, my lord, to look at my application.
Page 10? No.
Page 10 is the order of the tree officer pursuant to the technical advisory expert committee's report. The expert committee report, my lord, is at page 50.
There is no 5. 80. 24. Achha. Objections are filed by whom?
Objections are filed, my lord, by the petitioners. They've really raised 2 or 3 issues, my lord. One is compensatory afforestation. That your lordships have permitted us in earlier orders that it can be done in the BMRDA area. But my lord, one thing which I think is correct is translocation of trees. The translocation should be done within the area. So, my lord, we have identified another area where we'll do the translocation, which is within 1 kilometer, my lord, of the place where the trees are being uprooted.
The same rules apply to both compensatory and translocation. Here also, they're trying to do compensatory plantation outside the city. And orders of this honorable court have been passed saying that that will not suffice. That if you cut trees within the city and plant trees 45 kilometers
The
away.
learned friend also must be practical about these things, my lord. If I have to plant so many trees, there must be space.
there is.
I
no-
don't have space. I don't mind. If my learned friend can identify space, no, I'll
I have a more pressing submission to make, which is that this party keeps coming before this honorable court and saying there is urgency. I must fell trees in order for development. This honorable court has passed multiple directions, including compensatory plantation as a condition for felling trees. This OM which is sought to be enforced today is an expansion of an OM which is already allowed in 2022. In September 2022, they were directed to plant 4,000 trees as compensatory plantation. 3.5 years have passed, not a single tree has been planted by them. 3.5 years. They came saying urgent, we want to fell the trees. The Honorable Court put a condition on them to put compensatory plantation. They were supposed to do two kinds of compliances. One was to do the compensatory plantation, and second was to report on a quarterly basis to this Honorable Court whether they have done it and whether those trees survive or not. For 1.5 years, no quarterly reports are filed. Now they give us quarterly reports today that up to last year. And even as per that, 4,100 trees, not even one tree has been planted. In relation to an order dated 13th September 2022, in relation to the same project, the same location where they want to cut trees today, they say, allow me to cut further trees and impose obligations on us for compensatory plantation. Those obligations till today are not complied.
It's done.
No, there is no the compliance report they have served us yesterday
I have
says
instructions that it is done.
yesterday they served us a compliance report, quarterly report, which says it is not done. This is the report that was served on me yesterday.
But now, my learned friend Lord has to also appreciate one fact. It's all right, Lord, I understand. Whatever has to be done will be done. There's no question. We can't violate.
3.5 years, it's not done.
My learned friend, grant me a minute. I understand my learned friend's anguish, my lord, that trees have to be preserved. It's not like, my lord, we have some real intention to destroy all trees in Bangalore and proceed. It's not as if, my lord, the entire right to maintain trees is vested with the petitioner. So, my lord, petitioner has to also see that there has to be sustainable development. I have to also ensure that the interests of the public, my lord, who want to travel to the airport is ensured quicker. It's all right to say, my lord, we should protect the trees, but how do I protect also the interests of passengers who want to travel? The amount of carbon credits, my lord, which we get because of travel by metro, we ensure that so many more cars are out of the roads. Now, I'm not saying, not for a second, nor am I justifying if there's any delay, that delay cannot be proved by this honorable court. I will not ensure that all of that is done. But that can't be a reason to say, now don't continue with the development activities.
Widening the road.
Beg your pardon, Lord?
Metro project.
Metro project, not is the elevated metro project, which has to go to the airport.
There you are replanting up at the distance of 5 kilometers.
45
No,
kilometers.
no,
my lord.
45.
In Nelamangala Taluk, outside of BBMP jurisdiction, 45 kilometers away.
But now I'll tell you lots what the problem is. I cannot plant trees in someone's private property. My lords will not have.
At least 10% of them can be immediately.
I think you should be thinking of underground metro at least, like in many cities. See, the problem is in so many areas, trees have been cut. I mean, your metro passed through the areas where the trees were standing. You look at Jainagar, that south end to, what do you say, that JP Nagar Ring Road.
The cost of doing an underground metro is 10 times the cost of regular metro.
No,
And
whatever, that alone can't be a factor. See, that was one avenue of around, how much? 3 kilometers? One of the best stretches we had.
The idea, my lord, is always to build it on the road. Most places your lordships will find the metro is built on the road. But there are certain places, my lord, where the alignment changes. To ensure that the alignment, my lord, matches with what we have to plan, there will be some trees which have to be cut. Now, my lord, it is not our intention not to cut trees. I don't want to cut trees also. It can't, the manner in which my learned friend...
We'll go through the objection and then decide.
I only one request now, my lord. There are, in so far as the trees are concerned, out of the 55 trees, we have not been told by the expert committee that a total, my lord, of 55 trees can be removed.
We'll see on, say, fourth.
The only difficulty in all of this, my lord, is
We
the
know your urgency on your part.
increase in
But
cost.
let them show some bona fides and
Lord, my-
urgency in
my-
complying with the court's orders.
Increase in cost, my lord, is so significant with every passing day.
In
That,
fact,
my lord, I can understand not in any other project, but this is after all
So,
a public project.
I'm not opposing the project at all.
You're opposing the
I'm
project.
not opposing the project at all. All I'm asking is that the sanctity of this honorable court's orders be maintained.
Will examine, but you
Please.
passed more than one orders in other.
Yes, my lord.
I have
Not since permitted.
Whenever
Plantation
they have been in compliance, I have, and my learned friend will vouch for this, we have come and said they are in compliance, the order may be passed, allowing the trees to be cut. But they are in blatant non-compliance for years of the directions of this honorable court to balance out this honorable.
We'll do fourth.
Very well.
Deeply obliged.
Pradeep.
28 is urgent, seal number 29. The Prakash MH.
Please. So the accused have submitted an affidavit disowning that they have not committed any contempt, but still it is not a justification. But in a pending writ petition filed by the petitioner against BDA and the accused herein, well, the site which was allotted to him way back in 2003 and which was registered in 2004, but after 19 years, without even intimation to the complainant, my lord, this site was subjected for action sale, wherein the accused are the successful persons. But subsequently, an intimation was sent to the complainant seeking his cooperation for cancellation of the sale deed of the year 2004. But immediately the complainant has approached this honorable court, even by making the accused, both the accused as the parties. On earlier occasion, since the documents relating to, the sale deed executed pursuant to the auction sale were not secured, only the notice of intimation was under challenge, and the learned single judge has granted interim order of stay. But after appearance, my lord, both the accused have proceeded with developing the property, which compelled me to file an application restraining them from proceeding further construction, and also stop from making out, creating any third-party charges. Lord, may kindly turn to page 26, Annexure E. And two applications are filed for seeking amendment and direction. I would like to invite my lord's attention to page 28, order on IN number 1 of 24. Now, the case of the petitioner is that the property which is the subject matter of the writ petition was allotted to the petitioner by the Bangalore Development Authority. Subsequently thereafter, after lapse of 19 years, the same has been wrongly put up for auction. And respond number 3 and 4 are the successful bidders, and they are putting up construction on the said property in a hurried manner. It is further submitted that if the respondent 3 and 4 not restrained from putting up construction, the petition will be put to irreparable loss and injury. Lord, kindly note this, the learned counsel for the respondent 3 and 4 absent.
It's an interim order.
Please, interim order. And my lord, they have not filed even statement of objection. They have not even appeared. And there is a blatant violation of the interim restraint order granted by the learned single judge. And they proceeded with.
Go before learned single judge. You are for whom?
Accused.
What do you say?
We have not waited any order. Can we see the
The
photo
order
just
brought
produced by
under this
themselves only?
contempt- The order brought under the contempt jurisdiction by filing this petition is admittedly an interim order passed in the pending proceedings of the writ petition. The petition and the subject matter thereof is pending at large on merit to be considered by learned single judge. By very nature of the order, the rights of the parties are not finally crystallized. In that view, the court is not inclined to invoke the jurisdiction under the Contempt of Courts Act 1971, leaving the petitioner to approach the learned single judge in the pending writ proceedings to work out his rights and remedies. This court does not express any opinion in that regard. The contempt petition is not entertained and disposed of accordingly.
30, to Srinivas K.
For the complainant. Yes. Lord, my counter affidavit, my lord, is ready. I will file it, my lord, during the course of that.
Court counter, what is the order?
The order, my lord, is to consider the representations of the complainant and to pass appropriate orders on the same.
So it is passed or not passed?
They have, my lord,
Passed, yeah.
issued endorsements saying that once the financial condition improves, they are going to pay the, my lord, the remaining arrears. They have paid, my lord, the interest on the gratuity amount, but insofar as, my lord, earned leave encashment and other terminal benefits, my lord, the arrears are yet to be paid by the accused authorities. So, the employees have retired in 2012 and 13, my lord. Till date, my lord, the arrears are yet to be cleared. My lord, they cannot, my lord, keep the, my lord, the employees who are already, my lord, on the verge of, my lord, they're already sufficiently aged, my lord, about 75, 80 years. They're virtually, my lord, undergoing great financial difficulties. My lord, they cannot, the authorities cannot keep the employees in, my lord, in tandem. And this is the third or the fourth round of litigation, my lord, between the parties. Every time, my lord, the employees approaches the court, they issue endorsement saying that once the financial condition improves, they are going to pay the amount. That is virtually not the testing the patience of the, my lord, retired employees. We have served the company for more than 30 years. I'll file my, my lord, counter affidavit, kindly have it next week.
Lord, the subject matter of the writ petition, Lord, was only with regard to the payment of 1992 arrears. That has been paid. Subsequently, they have made representations also have been considered.
You are HMT, no?
HMT, my lord, it's a sick company, my lord, and they tried and paid the gratuity amount, also they paid the 10% interest on that. Now, with regard to 1992 pay scale, they have paid the arrears also. And now they are filing a fresh representation asking for 18% interest on it. Company is sick.
The liability?
Liability, my lord, only in each case, my lord, 2 lakhs and odd rupees. My lord, they will pay, my lord, on seniority basis. They are paying. They are trying to pay. They are not disputing.
But
But
with some mechanism or time-bound program to pay.
Please, my lord, this matter, my lord, consider the.
We will not permit you to just saying that we will won't pay because of financial. All right, financial understand may be a good ground, but then when you are going to pay? It is a matter of compliance of the court's order.
My lord, the only with regard to EL encashment, I am liable to pay, my lord. EL encashment, you have paid the gratuity amount and also paid the 10% interest on the gratuity amount as directed by the ALC. And in fact, they also paid the 1992 pay arrears. Only with regard to EL encashment, my lord.
That part, when you are going to pay?
Maybe some time I'll just maybe
take instruction.
This 8 weeks time maybe. No, I will try.
Give you time, 3 weeks. Send over to 27th February. Within which time learned counsel for the respondent company shall take instructions as to the time-bound schedule within which the respondent company paid arrears to the petitioners contemplated.
EL encashment. EL encashment, my lord. EL encashment. EL encashment. EL encashment. Earned leave encashment.
Earned leave encashment contemplated in the directions of Learner Single. 10 over to 27.
Public.
Because it appears to be, you may be right, but then still you just try to find it.
Number 31, Mr. Siddharth Pandra.
Lordships had directed them to have a WhatsApp conference with the children, father. They have complied in the last occasion. They have complied. My only request is, not sir, if this arrangement can continue until the order is varied, petition could be disposed of, subject to what my learned friend would say. There is an,
Matter is pending in the trial court. My lord.
unless therefore I said,
Same order
until,
continued pending disposal of the case.
correct.
No objection, my lord.
So this last order, seven one
And matter
twenty-five.
can be disposed of.
Can, please, we can. Previous order of the Honorable Chief Justice. This arrangement,
The subject matter of the present contempt petition and the directions which were required to be complied with by the respondent regarding visitation rights of the other was highlighted by the court and was highlighted by the court and was reflected in the order dated 7/1/25. The order records the paragraph, pura order code. It was provided in the order that respondent shall facilitate the talking by two minor sons with the applicant father on WhatsApp call. The father, since stays at foreign country, the WhatsApp video call time was also fixed. And the talk was to take place on 12/1/25 at 11 AM. Full stop. It was provided that the two minor sons may talk with the father, applicant father, at least for 15 minutes or until they prefer to talk. Full stop. And the present petition came up for consideration, comma. It was a matter of satisfaction for the court to record the statement of both the statement jointly made by learned senior counsel Mr. Navragi, representing the applicant father, and learned senior advocate Srimati Premila Mesargi, representing respondent mother, that in terms of the directions in the aforesaid order, the two children could talk with the applicant father on the day and time fixed on WhatsApp call. Full stop. It was encouragingly suggested, paragraph, by both the sides that the same arrangement may continue so that the children could speak with the father, and the father has also an opportunity to mingle with the children. Full stop. It was further submitted that with continuance of the very arrangement, what proceedings are pending?
JNW, sir. Guardian and under the
proceedings.
Guardian, what sir?
GNWC number 135/24, pending before the court of 6th additional principal judge, Bengaluru.
Please.
May be directed to be completed.
Please.
Expeditiously and time bound. Full stop. The request is imminently, paragraph, reasonable. In light of that, the present contempt proceedings are disposed of by directing that the two minor children shall talk with the father and that the respondent mother shall facilitate such talking on every Sunday At what time? Same time?
Same time, Sunday, madam.
Sunday at
Same time,
11,
11 o'clock in the morning.
11 Indian Standard Time.
Yes.
Or as may be mutually convenient.
Madam,
Then
it's
it
a
will
working
lead
lady.
to uncertainty.
Sunday will be all.
No, that US timing sometimes. it
11
differs.
AM with that fixed,
No,
they have been
we
doing
will
it. 1
request-
hour they had a talk.
We'll
Last-
request, no, we'll work it out, should not.
Every Sunday at a time to be worked out mutually
Mutually.
by the applicant and the respondent, applicant father and applicant respondent.
Time zone differs, therefore we'll work it out.
However, the party is assured that notwithstanding the time not fixed in the order, the talk shall be invariably arranged.
Please.
On every Sunday.
Please.
The proceedings before the court below in the GNWC number 135/24 shall be proceeded with and shall be disposed of by the
Yes.
court within period of 3 months. 3 months,
3 months.
3 months or 4 months.
Both MC and GNWC are pending, my lord. He has filed a case for divorce.
Same court.
Which is that?
Both are, my lord, they are taken up together. We don't know. We'll do it.
But that is not, this contempt doesn't arise out of that.
There is no contempt, my lord. I am
No, it's
not,
all-
because it's a child's
No, it's
question. I am
lordship.
not.
No, if
there is no-
Lordships are.
The background of contempt, the proceedings only of GNWC.
Yes.
That's
So proceedings of GNWC shall be completed by the court below within 3 months from the date of receipt of the, from today. From today.
Today, we copy.
Full stop. It was stated that the divorce proceedings are also pending.
Pending.
Which
MC number, I'll just.
C number?
MC number. That's what it is.
This.
It's the MC number, my lord, so 4254 of 2024,
425424.
pending before the 6th Additional Principal Judge Family Court, Bangalore.
Same court.
Please.
Which is pending with same court? Are pending with same court, comma. Learned advocate the parties, senior parties requested the court that the said proceedings may be directed to be disposed of expeditiously, full stop. In this regard, it is observed that it will be open for the parties to make a joint request for consent for expeditious disposal.
Now it is before mediation. Anyway, my lord, it will come back.
What is the stage of this guardianship
Yes.
involved proceeding?
At the state.
3 months will be sufficient?
It will be sufficient.
One matter is posted on 24th of this month.
No, stage.
GNWC.
Evidence has not yet commenced. Evidence is not yet commenced.
MC is before the mediation.
Make it 4 months, 6 months,
6 months.
6 months, 6.
Six.
Present contempt proceedings are disposed of in the aforesaid terms.
Number 32.
My lords, I appeared for the petitioner in this case, my lords.
Correspondence, my lords. First, we have filed a reply in the counter, my lords. Copy has been served on the other side, my lords. Any date may be fixed for the.
My lords, kindly have this matter on the 2nd week of February, my lords.
Any day, my lords.
20th February.
Much
As
obliged, ma'am.
jointly requested by the parties.
Number 33. Mr. Vinay Kumar K. Vijay Kumar K.
After the learned single judge issues the direction, but the BDA seeks time on at least 4 occasions and still not complied with the order. But the BDA took a decision to allot the sites in 2019. They asked us to pay the money. We paid the money which they had earlier demanded. Then they again issued a fresh demand notice saying that including the money which we had already paid, you should pay a bigger sum. We went before the BDA and said, look, we have already paid this money. Difference amount is about 2.5 lakhs to 5.5 lakhs in respect of 2 properties. They were not ready to accede. So that forced us to come before this honorable court. Allotment letters were already issued. Lords, before this honorable court, my lords, there is a learned single judge's order, if I were to persuade your lordships to take page 14, my lords, 1-4. Because we are virtually, my lords, this is the 6th year. BDA is making us do rounds and rounds and rounds for the property which I have lost, and it is a compensation which they are paying me. My lords, page 14. Learned counsel for the petitioner, para 2, my lords. The learned counsel for the petitioner drawing the attention of this court to annexure D and H, whereby the petitioners was called upon to pay aggregate sum of rupees 60 lakhs 36,420 and 95 lakhs 12,060 respectively, submits that as against the said demand made in annexure D in WP number 17408 of 23, petitioner has already paid 58 lakhs 35,900, and that only 2 lakh 520 is to be paid as against the demand made in annexure H WP number 20345 of 21. The petitioners paid 89 lakhs 80,844. Balance of rupees 5 lakhs 31,216 is paid. Learned counsel for the BDA does not dispute the amount paid by the petitioners above. The learned counsel for the BDA fairly submits
That
that
is
if
all
the
right, but you have paid this 2 lakhs and 5 lakhs?
we paid. Now, lordships will kindly find, my lords, that page number 20, 17th November 23, we have paid it.
Yes. So no, you're not executing the deed?
Not, even today, they have not executed the lease deed.
Right. As a final indulgence, lordships may kindly grant me a week's time, my lords.
It's an aggravated contempt as and when they seek for time, my lords. When the
No,
learned
the-
single judge
my-
directs that you have to accomplish this within a time prescribed,
May I submit, my lords? Files has been put up, my lords, just awaiting the commissioner's approval. Lordships may kindly grant me just a week's time, my lords. We have the.
if they are taking that week's time for compliance, my lords, I definitely not oppose.
My lords, it's the compliance, my lord, that we have to do. I'm not submitting anything beyond that. The file has been put up for the commission section, my lord. That's the instructions given to me. Just a week's time, my lord, may kindly be granted.
The directions of learned single judge in order dated 14th September 23, while disposing of the petitions, 3 days under. Bracketed portion, page 16. The contempt of aforesaid directions are alleged in this petition. It was submitted by learned senior advocate Mr. Ravi Shankar that the petitioners have already discharged their obligation of depositing the balance amount of rupees 2,00,520 and rupees 5,31,216 as reflected from the remittance challan dated 7th November 23, figuring on record of the contempt petition. Despite that, it was submitted that the respondent Bangalore Development Authority has not executed the registered sale deeds and the conveyance deed as directed by learned single judge. Paragraph in this regard, learned advocate Mr. So and so submitted that the file is under process and is lying with the approval of the commissioner.
Please, my lords.
We do not find the justification in this submission inasmuch as once, the court has directed the execution of the conveyance deed and the sale deed of the conveyance deed, the approval of the commissioner is a mere formality and should not book any unavoidable, any delay. In that view, while granting time up to the next date to the respondent, it is expected that the directions will be complied with before the said date, failing which the court may have to take a stern view. Paragraph stand over to 5th of February.
Lords, grateful for lordship's
Objection.
guidance.
Number 34,
To be listed at 2:30. So that it can be disposed.
Please, my lords.
34.
If you want little
Hey,
more
please.
time, get it, but
They appear for the
Understand.
complainants. Understood.
For the
The complainants
My
are
lord,
traditionally
accused is before
beef
the
merchants.
my lord, before my learned friend submits, I pray for a date to file the reply, my lord. Accused is before the honorable court. The rejection of my lord, the beef and my lord, selling of beef and other aspects, my lord, is challenged in the contempt proceedings. My humble submission is, my lord, I will place my reply, my lord.
They
You are-
point out.
you are for commissioner.
Yes, the commissioner is before the honorable court, my lord.
Our shops came to be closed 5 years ago after the ban on Cow Slaughter Act came to be passed. Now the Cow Slaughter Act does not prohibit sale of beef, and it is permitted if it is in respect of buffaloes. That is the only thing we have sought. This is our traditional occupation. For 5 years, we have been deprived of our livelihood.
23 order.
Please, my lord, my humble submission.
Kindly
is
look
this,
at
my
the
lord.
objections he has raised. Trivial.
My lord.
He has allowed the meat shops. He has allowed the
My lord,
chicken shops.
I know, my lord.
Same conditions apply.
My lord, I know my limited submissions and scope of my submissions will be very much limited before this honorable court in contempt jurisdiction.
No, we are only pointing out.
Please, my lord,
Time-
only.
Time was given for 30 days, that too in 2020.
My lord, that immediately, my lord, an endorsement was given. Later, my lord, they were asked to furnish some details, my
Now
lord.
what you are proposing to do?
My lord, I will place my reply before the honorable court. And my lord, they have said that, my lord, I have violated. My lord, I have not violated the orders of the honorable court. And my lord, the endorsement issued by our office is, my lord, that they have not.
Directed to consider the application.
Yes, we have considered.
They
my
have
lord.
given an undertaking to give the trade license under conditions.
No, my lord.
Let them impose any conditions. We have
My lord, conditions are not complied with.
kindly,
This is my anxious.
kindly
submission.
see, conditions are no license is given. The undertaking is that if we restrict it to beef, they will give the license on condition. They have never given a license.
You are supposed to give licenses.
Yes,
My lord,
381, section
please.
381 of the.
But my lord, annexure F, my lord, we pointed out that, my lord, they have not furnished all the details necessary. Even on the earlier occasion, my lord, within 30 days, my lord, annexure D was also informed them, my lord, on 5/2/2024.
Gangadharappa was,
Yes.
you are.
No, my lord, I am another panel advocate.
Matter was argued at length
Yes, yes.
when the judgment was about to be dictated.
Please, my lord, I am another panel advocate, my lord.
On behalf of corporation.
Please, my lord. My lord, here in the para 4, my lord, that was the submission made by learned friend, by my learned friend, that, my lord, if all the requirements are fulfilled. My lord, therefore, my lord, another, my lord, endorsement was given immediately, my lord. Then they furnished the details. They were not having all the
So you
details.
are running your business now.
They have stopped it for the last 5 years, sir. We are without any livelihood.
You are the shop holders.
Sorry?
You are shop holders.
Yeah.
Yes.
Building this
Shop is closed because
Shop
we
is
don't have the license. We had the license. From time immemorial, we have been permitted.
What is your objection, Mr. Rams?
My lord, my humble submission is this, my lord. The annexure F, my lord, which they have questioned that it is not proper and correct. My lord, we have asked them, my lord, give all the details from my lord.
Give whatever details they want.
Everything has been furnished, sir.
We will be ready, my lord.
Everything has been furnished. Nothing is held back.
Let us see what is annexure F.
Yes, kindly. Well, before that, may I submit page 103 may kindly be seen. Look at the shops. In order to satisfy them, state-of-the-art mutton shops, beef shops have been put up.
They are new shops.
New shops.
New shops.
Newly, because they insisted that we should have tiles. We have provided tiles.
Now, where is
They
your
ins-
My lord, in the
They
order.
insisted that we should provide for drinking water.
My lord, the problem is, my lord, residential areas have been shown, my lord, and my lord, transportation will be difficult for them also. And the age of, my lord, the mutton of the buffalo, my lord, it will be very difficult, my lord, to make out, my lord, the age. And because, my lord, above 13 years is to be slaughtered.
That is not within our jurisdiction in contempt process.
Please, that's why, my lord, I submitted before the honorable court. My submission will be very much limited. My lord, annexure F, my lord, we have brought out all the lacunae in their applications, my lord.
Sir, F is what page?
Yes, my lord, 143, my lord.
143.
Please. My lord, they have, my lord, as per the orders of this honorable court, earlier, my lord, annexure D was also given, my lord. We requested them, my lord, you please furnish all these documents. They did not furnish incomplete. The annexure D is 5/2/2024.
Annexure F, I have given the
44.
translation also.
Please.
Kindly come to page 155.
Is that? Yes.
Page 155. Objection by objection. Everything has been met. They record it. Kindly come to page 155. Ownership of the premises. They question the ownership of the premises. So we have produced the title deeds.
That was in the
Kindly look at
residential
the
area.
triviality of their objections. We produce the title deeds. It is not their business to find out whether I am in a rented shop or in a.
How many you are, how many in number?
We are only 7.
7.
We are only 7. For the last 5 years,
But similar applications were also filed earlier.
You pass individual orders in respect of each,
Please.
of whatever nature you want to pass, then we'll see whether you are committing contempt or you are complying.
My lord, I will-
sir, kindly see the date of the
before
order.
that, my lord,
Kindly see the date of the order.
We have seen it there, we have impressed.
They
my lord,
took and
that's true,
gave
my
an
lord. I
undertaking
know, my
when
lord,
the
my
judgment was about
my
to
lord,
be pronounced.
my humble submission is, if I place the reply for this, my lord,
No reply. It doesn't book any reply. Either you comply or tell the court about the non-compliance and reason, your reason, individual reasons. In individual cases, 7 cases are there. This general thing will not do. Or you
Please.
comply with.
individual, my individual.
You comply with, if you are still of the view that we will not comply, then give individual.
No, my lord, I am sorry, my lord, I should never say, I will never say, my lord. As an officer of the honorable court, I know my limitations. Lord, I have also advised my client. But the difficulty is this, my lord. If they produce all the necessary documents, my lord, definitely that may be.
So that is what we are saying, that ask individually what document they want, they will produce it.
Please.
Sir, everything has been complied. All the documents have been furnished.
Let's see what they want, they are right, wrong, they are projecting the excuses.
Very well. No, the undertaking is they will give the trade license if we confine it to beef and impose conditions. Where is the license? 5 years they have denied me license.
My lord, in para 4 of the orders, my lord.
Sir, a very restricted scope is there. Beef can be only in respect of she buffalo, age 13 years
13 years.
plus, or he buffalo without any age restriction. That is all what is being produced.
My lord, to transport, my lord, agreements have not been renewed, agreements are
There
not
is a
produced.
commissioner who is hell bent on denying us the license.
No, I'm sorry, my lord, that's not.
Please direct him to be present before the court. If necessary, I'll even cross-examine him to show what kind of prejudice he is entertaining against.
No, not like that.
It
my
is
lord.
the community
No.
which is
My
the
lord,
root cause of
I take a very strong
very,
exception.
I
Submission of
will
my
demonstrate
learned
it.
Senior counsel, not such.
I will demonstrate the kind of prejudice the commissioner is carrying.
Not like that.
Kindly see how many times he raises objections. Every time we comply. Every time we comply. Every time he comes with new objections. The undertaking is he will give the license imposing conditions.
My lord,
That is all what is.
my lord,
We are only insisting, let him impose any conditions. We'll comply. And
This,
please, sir.
See, come to para 4 of the order.
Please, my lord, please.
What is irrelevant?
My lord, the.
So and so submits that corporation has not prohibited petitioners
Please, my lord.
from carrying on the trade of meat in Shimoga.
Please, my lord.
That includes all types of meats, including beef. Okay?
Please.
Then the slaughter is not in question over here.
Please.
It's only, this contempt is limited to meat trade.
only trade.
Then he submits that if application of the petitioners is restricted to trade, the same would be considered by imposing necessary conditions to safeguard the interest of consumers
Please.
and other stakeholders.
Please, please.
And the order passed is, respondent number 2 is directed to consider the application submitted by the petitioners in terms of the submissions made by so-and-so, learned counsel for so-and-so.
Please.
And necessary trade license granted by imposing such conditions as may be necessary to safeguard the interest of the thing.
Please.
So once and for all, you have to clarify what is the conditions that it is subjected to in accordance with law.
Please.
If they comply, it has to be granted.
Please. No,
It's
my
as
lord.
simple as that.
Please, my lord.
is
No,
a
I know, my lord.
2023 order.
My lord, in
We
annex
are already in
F.
2025.
My lord, I am sorry, my lord.
We are
Annex-
without any livelihood.
My lord,
That is the
anxious submission of my learned senior counsel, I can very well understand, not only as a counsel, as an officer of the honorable court. Annexure F, my lord, we have informed.
No further debate.
Please.
Passed as back as on 8th.
My lord, my humble submission is, we
Nothing more. This is a contempt jurisdiction, we are.
I know very well.
That's all. Passed as back as on 8th December 2023. The order of learned single judge disposing of the writ, allowing the writ petition partly contained the following direction. Then quote 3, bracketed portion at page 15. The trade licenses for the purpose of trading meat to the applicant shop owners was to be granted within 30 days by imposing conditions as may be necessary to safeguard the interest of the consumers and stakeholders. Also, the aforesaid direction paragraph were passed in the background of the observations made by learned single judge in paragraph 4 of the order, which was again based on the submission of the counsel for the corporation. Then quote paragraph 4, full stop. Learned advocate Mr.
Ravi Verma.
Professor Ravi Verma is entirely justified that the passage of time in non-complying with the directions have aggravated the conduct on part of the respondent number 2 commissioner. Full stop. Learned paragraph. Learned advocate for the respondent number 2 commissioner submitted to invite attention of the court to Annexure F, which is a postscript dated 2/8/24, in which certain aspects are indicated. Full stop. They are in the nature of certain conditions to be fulfilled by the applicants who are to be granted the trade license. Full stop. The court in the contempt jurisdiction is not inclined to go into those aspects, comma. It is provided that unless the directions of learned single judge are complied with before the next date, the court will be compelled to take a serious view. Please, though it is observed that while granting the trade licenses, comma, it will be permissible for the corporation, for the commissioner to prescribe the conditions as already contemplated in the observation and direction of the direction. Please put up on
Short date, may kindly be.
less
My lord,
days.
some breathing time, my lord, kindly. my
What
lord.
is the breathing time? 2 years already.
No, my lord, my learned friend knows, my lord, where I stand, my lord. That's why, my lord, I am humbly praying the honorable court, my lord. Kindly, my lord.
We'll say 6th of March.
Please. I'm much obliged. Please.
But then do it, whatever you impose the conditions, but then the grant the license.
Please. I will.
They have granted license for chicken shop. Same conditions have to apply.
My
For
lord,
meat shop, same conditions will have to apply. Buffalo doesn't carry any additional burden on the commissioner except the prejudice in his mind.
no, my lord,
I'll demonstrate.
in a lighter way, I may humbly submit that I am totally a strictly vegetarian, my lord. I don't know anything about the different types of meats. But one submission is, my lord.
We are neither vegetarian nor non-vegetarian. We are only legal.
Yes, my lord. Sorry, my lord.
But that is what is
That's why
working,
I humbly submitted.
but that is what is working in the mind of the commissioner.
No.
Vegetarian.
No,
or
sorry.
non-vegetarian.
No, not like that. Not like
Evident.
that. My lord, if they give all the
He has
necessary
no objection
inputs,
for
my lord.
chicken shop. Same conditions will have to apply.
Don't impose such irrelevant conditions.
Sir,
No, I know, my lord.
there
I
is
know
a
very well.
prohibition for,
If they give,
there is a prohibition
But
for
I-
putting up a liquor shop. That they have imposed on us, saying that you are near this school.
but
near-
I will see that, my lord. I'm much obliged.
You could have challenged the order. That is the whole thing. Nobody prevented you from challenging. If there is some genuinely because. But having not challenged and attained finality, there is no way out.
No, it is based on their undertaking. Judgment was about to be dictated. To prevent it, he gave an undertaking. When I demonstrated, same
I will-
conditions
I
apply.
will verify and instruct.
All right, next.
Please, for
I'm much
35,
obliged.
you see that, Prabhu?
In this case, my lord, with the leave, the accused is present before the honorable court, that may kindly be noted in response to the notice. That may kindly be noted.
But it was in response of some order.
Yes,
Order was passed to keep.
yes. She is before the honorable court. Presence may kindly be noted.
Presence of learned commissioner is one for hearing. Personal presence of, there is no order. Why should we?
Please.
We have noticed.
Please, my lord,
This
the
case,
pair-
my lord, I represent the accused number one, my lord. In this case, my lord, I represent the accused number one. My lord, a review petition has been filed, my lord, against the order which is under. A review petition has been filed. It's listed today, my lord. A review petition. Review petition is listed today. It may kindly be taken up after 4 weeks, my lord, so that I can.
My
make a
lords, I was
submission.
not made aware of this review petition, my lords.
It's listed
Coming
today,
to my
lord. It's in
notice,
Seal number 80 and quote number
Stated by
50.
learned advocate Mr. So-and-so, so-and-so for the
my lords, if the
respondent.
details may be kindly.
Application is filed in respect of
549.
the order
Yes.
brought under the contempt jurisdiction. Comma, time is granted to the respondent on condition that within next 4 weeks, comma, appropriate orders in the review petition shall be obtained, failing which the respondent shall comply with the directions and the compliance shall be reported to the court. So we'll give a 1 week more than 4 weeks.
On my
7th
submission-
March.
My submission, my lord, for it can be, after 4 weeks, my lord, it can be called, my lord. I will just report that,
7th
my lord,
March.
and
7th March. Do whatever you want to do and report on 7th March.
Please, my lords.
Case number 36, Shilpa Rani.
In this case,
Yes.
I'm appearing for the respondent, one matter. Present complainant, they have filed one more complainant, contempt petition that is called on 6/2/2025, my lord. The present complainant, they have filed one more contempt petition, which is pending before this court, my lord.
I have not filed any contemptation. This is the only one contemptation I have filed.
My CC number 1097 of 2024, my lord.
For the very petition. Same petition.
Same petition number. My pass on this.
Advocate?
Advocate is different, my lord. In this contempt petition, my lord, the second contempt.
This 1097 is subsequent to this.
Please, my lord.
This is Satish Shivraj.
Satish Yuvraj Sajjan Sethi,
Ah,
the second
Here it is.
complainant in
Here it
the,
is Santosh.
that contempt petition, my lord.
In respect of the same order,
Very same order, my lord.
how can you?
I'll check with my client, then I'll come back, my lord, because I have no knowledge of another petition has been filed by the same complainant.
In the annexure A, my lord,
But the
It may be tagged along with my lord, any other date, my
Satish
lord, I'll come
Shivraj.
back.
Sajjan Sethi. Who is this Santosh? Petition number 4. There is no petition number. Common. It appears that lawyer is by mistake.
maybe.
Santosh.
It may be tagged along with that, my lord, then I'll come back, my lord. Have no,
We'll detect you from either of the petition.
I'm not
And
aware of
impose-
this.
And impose cost.
I'm not aware of this contempt petition filed by
Whomever
the other.
your client is well aware.
I'll
And
check
this
with my client.
1097 is
That is why I have filed first, my lord, then someone has been filed after that, my lord. Then
maybe not be at fault personally, but then find out what is happening at your end. 106 and 24. When this contempt comes up for consideration, learned advocate Mr.
Respondent number 1, my lord.
So and so, number 1, stated that that in respect of the same judgment and order of learned single judge, which is made subject matter to the present contempt petition. Another contempt petition number 1097/24 is filed, in which the present petitioner is also a petitioner. Full stop. Both the contempt petitions shall be listed next.
6/2 and 10, second contempt, my lord, 1097, it's called on
6/2, my lord. 6/2, 6th of February. Post of learned editor of the applicant shall take necessary instructions telling which seriously will be taken.
Much.
Number 37, Mr. Nagaraj asked.
For the petitioner, my lord, petitioners, the matter pertains to acquisition proceedings by the BDA, and there was a direction by this honorable court for making consideration of the representations of the petitioners for dropping the lands belonging to the petitioners from acquisition proceedings. And the representation has been made, my lord. It was supposed to be considered within 3 months. The same is not yet considered, my lord. The relevant portion of the order is at page 34. 33. Para B, my lord. The appellants are permitted to make representations within 15 days from today. Your lordships got that, my lord? Page 33, paragraph B.
Your Lordship, initially they had not submitted documents pertaining to their representation. Subsequently, we have considered their representation. We have given an endorsement also, but I will produce that before the court. Your Lordship. We
No,
have
my
given
lord.
an
Your lordship may
endorsement.
kindly see the acquisition proceedings as per the BDA council submissions at page 24, my lord. Page 24 of the order, para 7. The learned counsel for the authority, Mr. Murugesh, which submits that the power to delete the land from acquisition vests only with the government, and it is for the state to take decision with regard to deletion of notified lands from the acquisition proceedings. The submissions of the council, learned council is placed on record. BDA, they themselves have submitted before the court that they have no authority to delete the land, so it is the government which has to take action. Accordingly, we have made a representation to the government.
My lords,
Annexure B is
page
the
24, my lords, the direction is there. It is to state government or the competent authority. Your Lordship may kindly take page 33 of the contempt petition. Very clearly says if such representations are made to state government or the competent authority within 15 days. So it could be either state government or the competent.
that doesn't mean that whoever has the legal authority, they have to take a decision in the matter.
They have said that they have taken and passed an endorsement and they are going to produce on it.
Yes, but we have already complied our part.
Learned editor of the respondent in response to this contempt petition stated that the endorsement pursuant to the consideration
Not
of
an
the
endorsement.
as directed by learned single judge, has been passed, and that the same shall be produced on record.
It's a may I make a, it's not a letter, it's a letter. Ma'am. It's a letter to the state government.
What?
It is a letter to the state government stating that this person has not produced any documents to show title over the property. Under those circumstances, no decision from our end can be taken, is what is there in the, and Lord,
So it all is on your court, madam.
That's the direction is for the competent because they don't produce the documents.
Now they have written to you, you must take a stand.
Obliged.
When this contempt, again, when threshold, when this contempt petition comes up for consideration, in which the directions of learned single judge involved is about consideration of the representation of petitioner by the state government of the competent authority in respect of the dropping of
lands from acquisition proceedings.
from the acquisition from a learned advocate, Mr. So and so for the respondent BDA. BDA.
Yes, BDA, state government.
BDA stated that they have already written. They have already sent a recommendation. Recommendation.
yes, we report, it's a kind of a report to them.
Has already submitted already forwarded a report to the state government, and that the state report is to be considered by the state government to arrive at an appropriate decision at the end of the government. END, full stop, learned additional government advocate paragraph. Srimati Pramodini Kishan shall. Yes, what you will do?
My lords, we will take a decision, my lords.
Shall take, stated that the government shall
We'll
take. an
consider the
appropriate action
representative.
on the report, and the same shall be communicated to, shall be, and the court shall be apprised of about the same. Stand over to 10th of March.
Obliged.
Number 38, to Satish K.
Lords, in this matter, my lords, the order passed by the learned single judge is to implement the order passed in the RSA. Lords, against the RSA, state has preferred a SLP, my lords, it is dairy number has been given. Lords, the order passed is to implement the order of RSA number 894 of 2012, my lords,
Yes.
against which we have filed SLP, my lords.
Lord, the RSA, Lord, is dated, my Lord, 19/6/2023.
But then any
But,
alternate is filed, any order is obtained from the Supreme.
About, my Lord,
Not yet, my lords, we have obtained the day.
Let us see what is the filing
Lords, this is only a dairy number we have obtained, my
diary
lords.
number.
Please.
Lord, may I submit this? My Lord?
Sorry.
Lord, RSA was passed, order was passed in RSA, Lord, 894 of 2012 on 19/6/2023. 1.5 years ago. Lord, the very same submission was made before the, my Lord,
What is to be complied with?
Lord, mutation, my Lord, in favor of the petition, name of the, my Lord, petitioner should be mutated in the revenue records. But subject to result of, my Lord, may I request, my Lord, kindly come to page 20, my Lord, para 4.
Filed only on 3rd January. That is that too after filing of this.
Yes, we'll
Ah,
pursue it, my lords.
After, my Lord, receipt of the notice, my Lord, may I request, my Lords, to kindly take, my Lord, page 20, para 4. Very same submission was made by the state, my Lord, para 4 of, my Lord, Honorable Learned Single Judge's order. Learned HCGP has tried is persuade this court not to grant any indulgence on the ground that state is contemplating in preferring an SLP against the judgment and decree. Lord, I have got the decree, my Lord, in the year 2012. That is, my Lord, on 10/2/2012, RA was allowed.
To do it subject to the outcome of the SL.
Lords, I'll take instructions on this, my lords.
Take instructions, I will direct, unless you. 5th of March at 2:30.
Like,
Lord, next week, my Lord.
Let them have,
Only to take instructions, my Lord, your Lordship may.
will be able to take instruction next.
no, I'll take instruction. My lords, I'll
Next.
take instructions, my lords, make submissions.
Which date do you want?
Lords granted a time.
5th March, let us.
39 is urgent. Number 40, to B.C. Sita Ram Rao.
That's for the complainant. I appear on behalf of the advocate on record. There is slight inconvenience, personal inconvenience, since he was not.
Complied the order.
10th,
But,
complied with your.
Please, my lords, the objections has been filed. He has instructed me saying that objection to the complaints order has been filed. And it needs some consideration. Therefore, he wants to personally argue this matter.
While learned advocate for the respondent says that the order is complied with, learned advocate petitioner wants to file certain objections, put up at 2:30 on 5th of February. Please.
Your Lordship, serial number 49. 2 weeks time, Your Lordship, I will take.
11th March.
March.
Shared with Ba-
49, 11th March.
Satish sir.
Sir. Number is 40? ಇದೆ 230 ಲಿಸ್ಟ್ ಇಲ್ಲ, ಲಿಸ್ಟ್ ಅಲ್ಲೇ 230 ಮ್ಯಾಟರ್ಸ್ ಅಂತಿದೆ.
ಹೌದು ಸರ್. My lord, serial number 46, complaints is pending, my lord. I have to supply the second copy. But it's moved from the single bench to the DB. I'll have to provide the second copy. I'll do it in the next 2-3 days, my lord. It can be taken up next week. Serial number 46.
Office of Justice. We'll keep it on 3rd of February.
That's serial number 81, my lord.
81, yes.
Rest for time. Here is some information.
3rd February.
Another matter.
Pardon?
Serial number 51,
51.
51. I still have to obtain the certified copies from the learned single judge's court, petition copy. I have office objections to comply with. I'll seek 2 weeks' time.
2 weeks' time is granted to comply with the office objections, 50.
There is an interim order as well.
Failing with the appeal shall stand dismissed without order of court. Without reference to or order of the court. Interim if granted, areas will continue to operate till
There is an interim order as well.
18th of February. Put upon 19th of February if the office objections is fulfilled. Interim order is granted
Please, ma'am. It was moved in the vacation bench. We filed it in the.
and IA also pending.
IA is also pending.
Is ex parte granted.
Ex parte.
And office objection not removed, IA granted.
Ma'am, it's, certified copies from the learn, I'm unable to get the certified copies, means I would comply.
But then, what is, how delay also there.
Ma'am, I was not a party to the proceedings. That is why there's an application for permission also that is filed.
So leave to appeal.
Please, ma'am, leave to appeal.
There is no relief, court relief is there. There is no interim.
IA 3
Shall
of
not be
24 for permission.
processed.
Please.
The order granted earlier shall continue to operate.
Grateful. Manoj, I would need more than 2 weeks' time to comply.
Given 18th of February.
Grateful.
So 230 matters. Number 73. Chikkanagowda LS.
A memo has been filed, my lord, on 20th January, a memo has been filed stating that we have issued an endorsement rejecting the case of the complainant, my lord. They had asked for allotment of land on the ground that is a ex-serviceman, my lord. Now an endorsement has been issued saying that he doesn't qualify to be an ex-serviceman. So
No, it is incorrect. I will file my objections, madam.
No objection.
Just today, no. What has happened is, they say that my application for grant was under the ex-serviceman quota. And they say that I belong to,
Whatever they say, they have decided. That's
no. CRPF is included. CRPF is included in the ex-serviceman.
25th March. Sure,
Please.
next. Will not.
Number 74. So Prakash MH.
For the complainant, my lord.
Yeah.
We have received an endorsement, my lord. For the, wherein they have actually said they are not able to do the, Podi and Durast. Because they are not able to find the original grant, records. So actually, whatever was our original request is still not done. But however, we let me make a submission, my lord, that the liberty may be granted for us to challenge this endorsement.
The compliance affidavit, along with the compliance affidavit, endorsement is produced, which marks compliance of the direction of learned single judge. Learned advocate for the petitioner accepting the position that the directions are complied with and the contempt would not survive. However, requested that the permission may be, that the liberty may be reserved to the petitioner to challenge the endorsement on merits. Such liberty is reserved. However, this court does not express any opinion on the merits in that regard. Petition is accordingly disposed. Next.
This number 75. Vinod Kumar K. 75.
Complaints affidavit has been filed.
Yes, what is the proposition?
For entering the name in the revenue records, my lord, needful has been done. Needful has been done, my lord, for entering the name in the revenue records, my lord.
Learned advocate, the petitioner is not present to be listed on 6th of February at 2:30.
Yes. Number 76. The Sohani A. Ola.
We'll take up in the next. Sorry, next. 7th February, next please.
Number 77. Mr. Suyo Gerale.
Appear for petitioner's counsel, my lord. Say PIL, my lord, seeking implementation of EWS, my lord, so far as state is concerned.
11th March. Yes, next.
Number 78. Mr. Dhananjaya CP.
For petitioners here. This a writ under this is a bill with respect to the encroachment of the Mallashetty Lake near Kunigal, Tumkur district.
So, what is to be done? Yes, whoever. It is cleared, encroachment is cleared.
Yes,
It is cleared.
yes. So
The respondents are only facilitating the political parties, the political person.
Dismissed. Next.
79 urgents. Number 80.
Yes.
Mr. Rajendra KR.
Petitioner in this case, Lordship. 2 weeks' time may be granted to comply the office
To comply with what?
office objection, Lordship.
3 weeks is time is granted to comply with the office, failing which the appeal shall stand automatically dismissed without reference to or order book. We continue. There is no office objection. Madam, 22 years delay. Who are you? Appellant is.
For petitioner lodge.
Who are you? Purchaser.
Original grantee, my lord.
Son of the original grantee. 22 years and the petition must have been dismissed. Dismissed.
My lord, next date, the council, arguing council will come on.
Arguing council is not there, all right, to be listed on 5th of March, 5th of February at 2:30.
Choble lodge.
All office objections are dispensed with.
Much
So, next.
So 81 urgent, seal number 82,
Yes,
to Murthy K.
82, nobody is there. Days of filing, delay of 30 days in filing. 12th March.
Number 83, Mr. Karthik C.
My lords, I appear for respondent number 4 in this matter, my lords.
Nobody is there for the appellant. 13th March. Yes.
Number 84, Mr. Sampath.
Respondent number 1, my lord.
Nobody is there for appellant.
For short date, my lord.
No, sorry, 17th March. If you are not remaining present in 230 meter, we are not going to you.
He is an age-old man, my lord.
So why you are worrying? It is not your appeal. No stay, any stay is operating?
It's not the property, my lord, till now. For that reason, I'm taking.
10th February.
Number 85, Mr. Monesh Kumar KB.
So nobody is there, 13th March.
Number 41, Mr. Harish HV.
My lords, I appear for the accused, my lords. In this matter, my lords, there is a part payment that has been made today by the accused. With a request for 2 weeks' time, my lords.
Yes,
What part?
yes, sir, they have not paid, my lord. Have taken the details of the bank account. My lord, they should have paid on or before 15/1/2024, my lord. Even after 1 year, 1 month, my lord, they're still yet to pay.
We make this submission, my lords. This is arising out of an undertaking given by the accused, my lord. Pursuant to which there was 20 lakhs that was deposited, my lord. The total sum payable is 55 lakhs, my lords. Today, the bank details been added. Yes.
So what amount is required to pay total?
My lords, totally 35 lakhs has to be paid as of today. And 10 lakhs is being paid today, my lords.
Already in an order.
On the
4 weeks was granted. You are Mr. G.K. Nishan.
I'm his colleague, man.
on the last date also, my lord, the 20th order sheet. That 4 weeks was given to.
Appeal from the final degree proceedings had come before this court, wherein which the accused had entered appearance had given an undertaking. My lords, there was some difficulty, my lords, financial difficulty. That is the reason the timelines could not be adhered to.
Time may be given, my lord.
Please.
Let them at least comply, my lord, within the time what they.
Concerned with your money, it was stated that pursuant to the compromise degree, rupees 35 lakhs are liable to be paid, are required to be paid to the by the respondent herein. From out of which 10 lakh has been paid. Learned advocate for the respondent, Mr. So-and-so, 6 time for how much time?
That's why we seek for 3 weeks' time, my lord.
3 weeks time to pay the rest of the amount.
Please, man.
Full stop. The contempt petition shall be listed on 6th of February at 2:30.
Yes.
Unless paragraph. By that date, the entire amount is not paid and the directions are not, and the decree is not satisfied as per the order of on a single judge, respondent shall remain personally present on that day.
That's I'm
to
sorry, my
face
lord,
the
may I-
charge of contempt. Next,
my lord, may I request for second week of February, my lord.
you said 3 weeks, we are given more than 3 weeks. 11th February.
Please, great.
Please. It's number 42.
For the
Mr.
appellant, my lord,
Rajaram.
I seek 2 weeks time, my lord, to attend the office subject. 2 weeks time maybe.
Office objections. Office objections will be complied with within 3 weeks, failing which the appeal shall stand
Much of,
automatically dismissed without reference to or order of court. Yes, next.
Number 43.
obliged.
During the petitioner, my lord, the respondents have filed written arguments. There is some objections in that. My lord, they may be directed to comply that. My request for some time, my lord, 10 days time in.
So same order.
No, this, my
Yes,
submission in this case is, there was a caveat petition. The case where we had made a mention about the fact that even though the caveat was put up, it was not, name was not. It's our objections. Why should the other side be concerned? It's our documents. Only formality is to mark those documents. Alright, a stay order has been obtained.
Okay, third time.
My lord,
Do it, who you are for the appellant,
I'm for the appellant.
comply with it.
Please, it is there, complaint.
Interim
Weeks of
order,
communication.
interim order wouldn't subsist because this is a matter pertaining to.
That was made clear, my lord, by the previous order.
This
of
was a
this
matter
honorable court.
pertaining to a legal representative or a temple architect. Temple architect had filed the petition, he died during pendency of the writ petition. LR application could not have been allowed, therefore the court allowed the LR application and directed all parties to appear before the deputy commissioner. A submission was made in the court, I believe, because though the name was, the caveat was registered, it was not put up before the court. For some reason, it was suppressed. Now the interim order has been passed. Now because of that interim order, inquiry is stalled. Let the inquiry at least go on, my lord. Why should this inquiry be stalled? It's a process of law.
We'll consider on that day, on next.
Please.
Next week it may be taken up.
Yes.
Meanwhile, I may be also be permitted to make some correction for the documents to be marked as true copy, etc. That's what the office has raised. I may be permitted,
Kindly
because they
request.
will allow only with permission of the court.
Parties are directed to comply with the office of prison and make corrections as may be necessary in that regard within 2 weeks. from
1
today,
week,
failing
1
which-
week is
1 week.
enough. 1 week sufficient, please. Some urgency in this.
1 week, my lord.
1 week,
Any date may kindly be.
failing which the appeal shall stand automatically dismissed without reference to or order of court. Stand over to 10th February.
My lord, 10th February, there is some inconvenience. May I
Earlier
request
date-
it on earlier, before 6th.
3rd February. Next.
Obalish.
It's number 44. Mr. Ramesh Chandra.
For the petitioner, my lord, there was an order to implead the respond number 22 to 28, who were indicted by the Lokayukta. Lordship kindly address, there is no address to that. There, Lokayukta while indicting them. So your Lordship kindly go through the order. By order dated 4/10/2021. Suo motu content proceedings was initiated because of the violation of the order. I was directed to implead them. I have impleaded them, filed the cause title, but to issue notice, your Lordship may kindly see R22 to President Murukotte Sahit Samiti, Bangalore. The address is not forthcoming. On the basis of the report of the Lokayukta, have impleaded him. That's why government be directed to be, sir, I will pay the process, but the government has to be.
No, it's a BBMP who's involved. Why are you involving the government?
Or BBP, or whoever may be, because they were the employees of BBMP. R22 to 24. Your Lordship may kindly see the report of the Lokayukta, indicting them because they have violated the order. In order to serve the copy, address is insufficiently given, my lord, in the enquiry report dated 18/10/2022.
Who is appearing for?
I'm appearing for the Lokayukta, my lord. We have submitted our report, my lord, in this case. We have submitted our report before this honorable court.
Okay.
They have to be served. But since the address is not sufficient, I was not able to give the process, my lord. For the purpose of R 22 to 28, my lord, kind of thing. Address is not sufficiently given by the Lokayukta.
Find out the address.
Because
My
there
lord,
are
Mr.
BBMP
K.N.
employees.
Puttegowda no longer, my lord, I'm informed, doesn't practice, my lord. He appears for BBMP. My lord, some other counsel may be directed to be present so that they can assist my lords as to what has happened as on date.
Who appears for BBM?
My lord, he is no longer practicing, my lord, Mr. K.N. Puttegowda,
There shall be press notice to the respondent BBMP,
3 to 5.
3 to 5.
Yes.
Press notice to respond 3 to 5. Who are the BBMP and its authority?
My lord, even Chairman Marketing Standing Committee.
Manjunath, then President of Muthukkottai Sthayi Samiti from 22 to 28.
To enable them to make alternative arrangement by engaging a lawyer, engaging an advocate, since it was stated at the bar that the counsel who is on record is no more in active practice.
He is no longer practicing, he is not well, my lord.
He is no longer in active practice. Such a notice shall be returnable on.
And your lordship can kindly R 22 to 24, some arrangements has to be made, my lord. 28, they have implemented without address, my lord.
12th March. So for them, we'll go and find out the address.
Much of it.
By that time, we'll go and find out for each of them.
Yes,
Next
much
month.
of
It is not our job, your
Yes,
job.
my lord,
Don't
yes.
make irrelevant submission. If you are not able to find out, are you going to find out the address?
No, that's why Lokayukta has given report by mentioning their name.
That is your lookout. Yes, next.
Number 45. Okay, B. Vidyulata.
Milords, in this matter, Milords, they're constructing, Milords, a few channels and other constructions within Bairamangala tank, Milords, which is in prohibition of which is prohibited, Milords, with the Karnataka Tank Conservation and Development Authorities Act. Milords, this honorable court, Milords, had passed an order on 27/7/2021, Milords. Kindly see the order on 27/7/2021, Milords.
27,
7, Milords. 2021,
yes.
July 27. The question is whether the fourth respondent can be permitted to carry out the work in the tank area as well as in its 30-meter buffer zone The learned counsel for the fourth respondent will have to address the court in the light of the final judgment and order passed in WP number so-and-so, as well as the order dated so-and-so, passed in so-and-so, and in the light of the provisions of Karnataka Tank Conservation and Development Authority Act 2014, and in particular, Chapter 3, the learned counsel for the fourth respondent seeks time to 2 weeks to address this. My lords, they're putting up construction within a lake, and that too, the purpose, my lords, is to change the course of Rishabhavati River, my lords. The main contention, they do not even take environment clearance for this. They intend to change, my lords, the very course of a river by putting up certain construction within a lake area, my lords. Both the acts cannot be done was the submission when this honorable court, my lords, had passed this order. Till today, my lords, they've not come up with any explanation on this aspect.
Who appears for number?
I appear for respondent number 4.
Kaveri Niravari Nigam.
I appear for respondent.
You are the content. You are
Yes.
answering.
My lord, in obedience to the honorable court's order, I have filed an affidavit, my lord, on 4/12/2023.
Give synopsis, both of you. Give synopsis.
Some urgency.
19th February,
Some
24th February.
Some urgency is there. Work is stalled for a long time.
Pardon?
Short date, some urgency.
No, no short date, 24th February. Next,
24th February.
yes.
46. 46 urgent, symbol 47.
It's a public interest litigation, my lord, wherein a public park has been illegally occupied and pig rearing is happening in the public park, my lord. Pig rearing has been happening in the public park, my lord. Your lordship had directed the respondent number 3 last time to narrate the steps taken by them to evict the illegal squatters, my lord.
Lords, the affidavit is ready, my lords. I have served the copy on the other side. Lords, I permitted, my lords, I will file it in the counter.
File in the register.
Date may kindly be fixed, my lord. Kindly a date may be fixed, my lord.
25th of February.
It will be.
Symbol 48.
They appear for appellant.
For the respondent.
So I have filed a memo, my lords. Respondent number 2. Notice sent is returned as unclaimed, my lords. Therefore, notice returned to respondent number 2 is returned as unclaimed. Therefore, notice may be held as sufficient to R2, my lord. Notice may be held as sufficient.
No,
Service
not
of
sufficient.
notice.
You
It's
filed
returned as unclaimed.
IA for substituted, sir.
I have filed a memo.
IA for learned advocate for the petitioner is appellant is directed to file IA for substituted service since the present notice has returned unserved. Next.
It returned as unclaimed. Unclaimed.
Unclaimed,
May make one.
unclaimed.
May make one submission, my lord. With the leave of the court, my lord. With the leave of the court, may make one submission, my lord.
Pardon.
Please, my lord. My lord, the complainant in the contempt matter, who's the respondent in the writ appeal, is a practitioner advocate. Lord, it so happened, he was the tenant under the second respondent in the writ petition. The second respondent who had borrowed certain loans from the bank. The bank issued a notice and the bank sold the property to for an extent of 1,50,00,000 lakhs. The amount claimed by the appellant was only 1 crore for the to be given by the borrower. This 50 lakhs which is pending before with the appellants. My lord, I have filed an affidavit that, my lord, in the event I am liable to pay back, I will pay it back, my lord. He's a poor advocate who is practicing in the trial court. He was a tenant for no fault of his, my lord. The proceedings have been initiated. Lord, he has also filed an affidavit in page 14 of the contempt petition.
Where is that contempt petition?
Please, my lord, it is 48.1, my lord.
So then we don't know the subject matter. He is wanting to some, what do you want? Some substituted service?
Please, my lord.
Let him file. Yes, next.
Please.
49.
Number 49 is urgent. Number 50.
50.
Sagar BB. To Sagar BB.
Pardon?
A week's time may be granted
No,
to
why?
do the needful manner.
No weeks. We'll dismiss the. What is this VIL of 23? Why you are seeking for time? Yes, what is illegal? This is in park.
Yes, ma'am.
Who is for BBMP?
And for BBMP, my lordship.
So you are permitting the temple in park.
No, my lordship. My lordship, I'll get instruction, my lordship, because earlier advocate says no more, my lordship, who has appeared in the Chaitravati.
Pardon?
Earlier advocate says no more, my lordship, who has appearing the Chaitravati. So I filed invoice vehicle, I'll get instruction, my lordship, regarding my lordship.
Easy.
I filed.
Title changes, but subject matter doesn't change. Subject matter remains same.
Yes, my lord, I'll get instruction, my lordship. I'll get instruction from the officials, my lordship.
What
I
in-
filed invoice vehicle. So earlier advocacy has no more, my lordship. Chaitravati, see, earlier advocacy has no more, my lordship. Chaitravati, who has in the record, she is no more, my lordship.
Earlier advocate?
She has no more, my lordship. Chaitravati, who is a representative behalf the BBMP, she has no more, my lordship. I have filed already invoice vehicle, my lordship.
Is it part of the mini forest park? Or different?
It is within the park, ma'am.
Huh? You are saying JP Nagar fourth phase, 16th cross. I am asking you, is it that mini forest park?
Yes, ma'am.
Verify and state. Don't say it without that.
I'll get instant.
When shall we get?
A week's time, ma'am.
Week's time. 10 or 2. 6th February.
Much obliged. 51 is urgent. 52, the office objections matter, second time.
So unless 52, unless the office.
I beg to appear for petitioner, my lord.
Complied with within-
Apology, my lord, because my camera is
days.
not available. Kindly
Until
15
such
days
time
time may
as-
be granted, my lord, I will comply.
Automatically, without reference to or order of. Yes.
For third time, number 53,
53 same order.
number 54, third time,
54 same order. 55
55.
same order. 56 same order. 7
57 for fourth time,
4 time same order.
Same
58 same order.
55, my lord.
59 You said
59.
3 weeks instead of 4 weeks, same order. 60,
60.
3 weeks,
Serial number
Then-
59, it's become infructuous.
61,
Serial number
2
59,
weeks
it has
and
become
same order.
infructuous.
62.
I was appearing for the respondent, it has become infructuous, my lord. Serial number 59.
Where is the appeal? Learned 59 will be different. 59, learned advocate meets so and so, so and so. The respondent stated that the appeal has become infructuous. However, learned advocate petition is not present. In that view, it may be notified on 28th of January, 29th of January at 2:30.
59.
Then
Number
62.
61, 62 for 7 time.
same 2 weeks, 2 weeks. Then 63 also. 2 weeks,
63
same
for
order.
8 time.
Then 60.
My lord, 63, my lords, I appear for the complainants in the contempt, my lords. I may have some objection, my lords, because the contempt is not proceeding for the reason that they have filed writ appeal. And for 8 times, they have not complied the office objection, my lords. This is the 8th time it's
Order
listed
is
for
already passed,
non-compliance.
They will remove or otherwise the appeal will go dismissed. That's-
Office objections along.
Your
with
lordships may pass that
office-
preemptory order, my lords. May I request for a preemptory order, my lords?
No, we are not going to pass any other
Number
order except
60
which is already passed. Yes.
64.
64, yes.
Mahesh
I'm
Arkalpur,
grateful.
Council submission.
Yes, Mr. Nobody is there. Then it will go to 10th of March.
Number
None
60,
is present, send over to 10th of March.
number 65.
65, I appear for the complainant, my lord.
Yes.
I appear, the office objection is regarding limitation, my lord. The disobedience is recurring and continuing, even today it continues, my lord.
So who appears? Notices to go?
Yes, my lord.
Notice returnable on 14th February.
Please.
My lord, in 63, represent, I am the respondent number 5, my lord.
In this 65.
63, 63, my lord.
63 में क्या हुआ? What is it done? Some order is passed, 63.
2 weeks condition. Adjourn, my lord. Adjourn. Number 66, Mr. VB Siddaramaiah. 66.
Yes. It will go to none present. Stand over to 3rd March. All none present 3rd March.
67.
3rd, 4th and 5th distribute.
Lordship appearing for the
67.
complainant in 67.
67, yes.
Yes, yes. But there are some council submissions regarding why accused numbers 3 to 6 have been made parties to the contempt while they are not parties to the proceedings in which the judgment was passed. In this case, accused number 1 is Pebble Bay Owners Association, which is an association of owners in one apartment complex. They were a party to the judgment. 2 to 6 are all their office bearers or officials who have acted on their behalf or who've given instructions through which they have violated the order of the court.
So
So
office
they-
objections are dispensed.
We've made council submissions on this, stating that under section 12.6, as 12.4 and 12.5, they may be made party.
All officers are dispensed. For the time being, contempt petition may be notified on board by the registrar.
68. To
Yeah,
Shiv
my lord, I
Prasad
appear for
Anthony.
Lordship, notice has been issued in this, I couldn't hear what your lordship was, a notice has been issued in this matter.
It is issued or already issued? All that notice returnable on 18th February.
68.
I appear for the appellant. The only office objection raised is that in the plan sanction, there are 2 or 3 Kannada documents, Kannada
Serial-
words.
Serial number 68.
68, serial number 68, the plan sanction, my lord, I have produced.
English translation.
Yes,
under
only
I.
with respect to the document which is the plan sanction. Everything else, my lord, I have translated it. Only the plan sanction. There are these plan sanction, my lord, issued to the appellant for plan sanction. I am seeking dispensation of it. In
English
similar,
translation relating to the plan details is dispensed with
in the
for the
connect-
time being.
yes, in the connected.
Appeal may
matter-
be notified by the registry on 11th of February.
My lord, in connected matter, there's an interim order of stay granted. In the
What?
connected matter. If
What?
the matter pertains to acquisition by KADB, the 28-1 notification, my lord, can be challenged by this court. This is a common order passed. This is an interim order passed, my lord.
In
Both
some
were
oth-
connected.
In some other matter.
Similar matter, I only appeared, my lord, and
Then
it was-
let it come. Today we are not passing any. Yes.
but on a short date, my lord, for this reason, 28/4 is issued, then, my lord, my petition becomes infructuous. That is why, my lord.
Third February.
Great.
Number 69, Mr. Nataraj Ballal. 69.
69, none is present, stand over to 5th March.
Number 70, Mr. Patil Sanganagowda. 70.
Like, what is it, 70?
My lord, establishment of additional courts, my lord, to consider rehabilitations of persons who had been displaced because of the submergence. My lord, my statement is ready. I will file it. My lord may grant me 2 weeks' time, my lord.
Third additional district sessions is at Bagalkot. File, otherwise we will not entertain. 2 weeks. 11th March.
Obliged, my lord.
71, Mr. Dhananjay Kumar.
Appearing for the petitioner.
71.
Yes.
Yes, what is it?
My lord, say R7 is a quarry operator. He's operating quarries. There are houses within 200.
The driver changed.
My lord,
Why, my lord?
Yes.
they're using blasting equipments, and there's a school within half a kilometer radius. So while blasting the stones, the rock pieces are flying out and falling on top of the schools. There's also a temple situated, and also there are many persons residing within 200 meters. They have submitted representations before the authorities, before the geologists, before the pollution control board, before the deputy commissioner, and before the panchayat development officers, but none have been considered till now. My lords, my prayer is that.
Is it PA? No.
Yes, my lord, it's a PA.
PA?
Yes, my lords.
What is it about?
We are seeking consideration of the representation that we had submitted to the authorities.
My lord, it's only to consider the representations. The prayer is that.
The issue is whether you are granted him permission in accordance with
I
law.
will get that, I will get.
That-
but
that's it. If it's in accordance with law, taking into consideration all the required parameters, then the writ petition has to be dismissed. Otherwise allowed.
No, the prayer is only to consider the representation.
No, he is there, the affected party is here.
That's all.
I appear for R7.
Yes, my lord may grant me some time. I will.
Till the disposal, they may not be permitted to use the explosives.
19th February, within which time, 10 to 9, within which time a response shall be filed by the state government.
My lord,
Obliged.
I have a copy of the petition, my lord.
Give copy.
Yes, yes, my lords.
72, Mr. Rodavira Shetty, 14%.
14%. The office raised the objections regarding Rule 14, R1, sub-rule C, E, and D. I have completed the all office objections as per the rules, sir. Sir, in this writ petition, in para number, he has raised the objections regarding annex Rule 14, sub-rule 1, and sub-rule sub-rule E. C, E, F, G, H. These are all the minor subdivision. And I have completed office objections. And my prayer is, this is the larger interest of the public, sir.
Correct.
Because the neighbor countries people are suffering in the hands of the government of Bangladesh.
So you joined the president of the Bangladesh as part.
Yes, sir. And my humble prayer is to direct the government of India to at least protect the life of the neighboring poor people, your lordship. They are suffering in the hands of the governments. This is the matter. Because your lordship, during the year 1971-72, the government of India has supported to the Bangladesh. And they have ignored now. And they have unnecessarily they are created the problems and torturing to the poor people, your lordship. Then the poor people are not protected from the government, sir. And daily in newspapers and in videos, we are seeing the torture of the people of the in Bangladesh, your lordship. We are unable to give support. Therefore, this honorable court may kindly be pleased to direct the order to the Home Ministry, to the government of India, sir. Because this is the necessary duty of to protect the people, sir.
Heard learned party in person. Mr. Rodda Veer Shetty in this petition, paragraph, styled as public interest petition. The prayer is made, seeking a writ of mandamus and other directions to the respondents who are Union of India and State of Karnataka to protect the life, property and other religious places. Of Hindus and other minority community people residing in Bangladesh. Full stop. The petition is based on, is sought to be based on, petition, the prayer is sought to be based on some newspaper titled Prajavani Kannada. Newspaper report dated 13/8/24 based is the subject matter and the prayer is based on the news item dated 13/8/24 in Kannada newspaper Prajavani Kannada about communal unrest in Bangladesh. Not only the petition is peculiarly vague, from it is thoroughly misconceived and cannot be entertained in the public interest jurisdiction. It is summarily dismissed.
My lord, if I could mention a matter, serial number 64, it is under the caption of office objection with the counsel submission. By the time I could reach the court, the matter was adjourned. The office objection that is raised is that the accused number 5 to be maintained in a proper form. Accused number 5 is the partnership firm. So accused number 1 to 4 have been made, the directors have also been made the parties to the petition. That's the only office objection that is raised by the registry. The same could be overruled.
What is the office objection?
Office objection is that accused number 5 to be in proper form.
Do it.
Accused number 5 is a partnership firm, and since since it is represented by the partners are also being made accused in the petition. They're at the rank of accused number 1 to 4.
Petition is dispensed. The contempt petition may be listed on admission board on 6th of February.
Much obliged, my lord. My lord, if I also could make a submission, there is also one more connected matter. If that also could be connected with this, I would make the submission with the.
Their office of decisions is complied with?
In that, yes, my lord, it's complete.
That right.
My lord, I'll ascertain and I'll give the number.
Contempt petition?
Contempt petition.
Contempt petition, so and so number to be given.
Yes, my lord,
So
I'll
will
give it.
listed along with
Much obliged, my lord.
same date.